we have to mention for listing of an IA today, my lord. Interlocutory application, my lord. Your lordship was pleased to grant bail to the petitioner, my lord. To appear within 10 days, my lord, but he could not appear before.
Why?
Because there are some reason, my lord.
What reason? 10 days is sufficient time. Okay, you allow for this. Okay, hello.
For listing of a matter today for withdrawal, Lordship, the matter was fixed on 10.
May I please, Your Lordship, I beg to mention item number 14, Lordship, with the consent of the other side, Lordship. Early matter may be taken up after 2 weeks, Lordship.
You are appearing for whom?
Respondent 224 for Central GST.
Okay, the learned counsel appearing for the respondent as CGST. Praise for adjournment of the matter. Full stop. He submits that he has already taken the consent of the other side. Full stop. Let the matter be listed in the month of May. Interim order so passed earlier shall continue till the next date of listing.
Oblige.
Make this your lordship. Lordship, I beg to mention item number 4, lordship. The matter may be adjourned for the day, lordship. Conducting counsel is in out of station.
You are appearing for
Petitioner, lordship.
your name?
NJ Begum. On behalf of S.H. Sigdar.
MS so and so appearing on behalf of Mr. H.S. Siddharth, the learned counsel appearing for the petitioner. Praise for adjournment of the matter. Prayer is allowed. Let the matter be listed after the vacation. After in the month of May.
My lord, my name may be, or state my name may be.
Mr. And thus the learned counsel is
State.
present for the state.
May I please, Your Lordship, with the consent of other side, I beg to mention item number 3. Item number 3. This matter may kindly be adjourned for a day, Lordship.
You are appearing for?
J. Ghosh. She has some personal difficulties,
Okay,
Lordship.
the MS so and so appearing on behalf of MS J. Ghosh, the learned counsel for the petitioner submits that MS J. Ghosh has some personal difficulties today. Therefore, praise for adjournment of the matter. Let the matter be listed after the vacation. After the ensuing puja Bihu vacation. Yes.
Please, Lordship. I beg to mention item number 9, my lord. It's a criminal bail hearing matter, my lord. So service awaited, my lord.
Okay,
As per 6(4)
Mr. D. Bora, the learned counsel.
Service is awaited, my lord. I have come through the office note, my lord.
Okay, Mr. D. Bora, the learned counsel appearing for the petitioner, says that service in the instant matter is awaited. Therefore, praise for adjournment of the matter. Let the matter be listed.
Can it be on
Let the
22nd,
matter be listed after the ensuing Bihu vacation.
Can it be on 22nd of April, my lord?
After the Bihu vacation.
Should I fix a date, my lord?
No, after the Bihu vacation.
Fine.
We have already fixed how many matters.
Please, Your lordship.
Yes.
Lordship, TCR may be called for in this case, Lordship.
NDPS commercial quantity.
Earlier, one of the co-accused has been granted bail on similar ground, which we have pressed on through this petition, Lordship. If Lordship deems fit, Lordship, the TCR is required, then TCR may be called for.
What similar ground?
Lordship, violation of section 36, Lordship, in arrest memo, Lordship. There is no attesting witness, Lordship. Lordship will find on page 23, Lordship. Page 23, Lordship. And Lordship has
I
granted
heard,
bail to
heard
the
Mr. D. Medi, the learned counsel, appearing for the accused applicants. Also heard Mr. K.K. Boysa, the learned APP for the state. Where is the order, earlier order?
Earlier order, Lordship, I have recently checked, Lordship, I do not have right now, Lordship, but I have the bail application number.
No,
Which is
what
three-
will do with the bail application number?
I can produce it on next day, Lordship. I have mentioned in the petition.
It was seized from whom?
It was seized from, Lordship,
How you are implicated? You see, it is recovered from you or what?
from,
You don't
both the
write the
accused,
facts
Lordship.
properly in the bail application also.
From both the accused, Lordship.
Where have you written?
So that part will be there in the FIR, Lordship.
So why don't you state in the your bail application, only because it is a bail application, does it mean that you will not write any facts properly? You have to mention the facts properly. How are you implicated?
Lordship, 11 cartoons of suspected contraband was found from this person, Lordship.
That's what I'm asking from you. Your name is what?
Biju Biswas, Lordship.
But only Biswajit Saha's name is there.
Biju Biswas name is also there, Lordship.
Where?
In the forwarding, Lordship.
In the FIR it's not there. You're saying that FIR will reveal where from.
Lordship, in the FIR also, Lordship.
This is an application under so and so, you write it? Application under so and so, the matter relates to recovery of what?
Codeine, Lordship,
Cod-
cough syrup, Lordship.
Codeine cough syrup. Codeine cough syrup.
As
The-
cough, Lordship, name of the cough syrup.
You take it from this FIR. FIR, what is recovered is, it is written there. Okay? The recovery of this, the petitioner was, the accused applicant was arrested on 7/8/2024 P5, and since then he is behind the bars. Full stop. Registry to call for the scan copy of the TCR in connection with NDPS case
DPS
number
11 of
11/2026 pending before
Lordship, the district and session just Kamrup Metro, Lordship.
District and Session Judge Kamrup Metro. Let the matter be listed after the ensuing verification. You give some proper facts in the petition.
Neatly obliged.
The second round of litigation,
Hmm.
it is this initially, when we came to this court, there was an SOP issued by the state government at page 54.
Hmm.
Kindly see that the SOP. Well, this is the petitioner is a reputed organization working for promotion and protection of animal welfare and animal rights in India.
Hmm.
Now, if you see at page 54, 27th of December 2023, one SOP that was issued by the state government.
Hmm.
Now, this was about a buffalo fight and bulbuli fight.
Hmm.
Now, this was restricted only 15th January to 25th January, if your lordship kindly see at 55.
Hmm.
See 55 number 3, standard operating SOP guidelines. On the
Yes.
top, SOP guidelines.
Hmm.
If you see 3,
Hmm.
Mawjood may be allowed at a specific time of a year to be complete within 10 days succeeding Magh Bihu, that is from 15th to 25th of January.
Hmm.
Lordship got it?
Yes,
Shall
yes.
be allowed may at any time of the year except the period stated. So, my lord, here we are not now at the present concern of a bulbuli.
We are concerned about the modules,
Mm,
which your lordship, this was the standard operating procedure.
mm,
Now, there were a lot of restriction which was given, how the fight will be held.
mm.
This was put to challenge by us before this honorable court. And ultimately by judgment of this honorable court at page 31. Please see page 31.
Mhm. Yes.
And if your lordship kindly see at para 37. Para 37. At page 49.
Yes.
When no material have been placed by the respondent to show that bulls are not male buffaloes, in the opinion of this court, the question of exhibiting or training a male buffalo is therefore forbidden in terms with a notification dated 11/7/2011, or in other words, the male buffalo in terms with a notification dated 11/7/2011 cannot be used for buffalo fight. At this stage, this court further finds it relevant to mention another notification dated 7/1/2016 was issued there, whereby certain exceptions were made in respect to event of Jallikattu in Tamil Nadu and bullock cart races in Maharashtra, Karnataka, Punjab, Haryana, Kerala and Gujarat. However, the said notification dated 17/7/1/2016 was withdrawn, as would be seen from the order dated 31/1/2017 in case of compassion unlimited class action versus so and so of the Supreme Court. Now, please see another paragraph, paragraph 38, kindly see, man. Paragraph, paragraph 41. See paragraph 41 at page 51. This court further finds it relevant to take note of the judgment of the Constitution Bench in case of Animal Welfare Board of India in view of the fact that learned coordinate bench of this court had directed the Chief Secretary to arrive at a conscious decision taking into account the said judgment. A perusal of the said judgment will show that after the judgment was rendered in case of A. Nagaraj and dismissal of the review petition, the three states of Tamil Nadu, Maharashtra and Karnataka made amendments of the Act of 1960, and such amendment has also received the presidential assent. The Constitution Bench of Supreme Court in the said judgment held amendments which were carried out with the presidential assent minimized the cruelty to animals in the sports concerned, and once the amendment act along with the rules are implemented, the sports could not come within the mischief sought to be rendered by section 311(1) A, M and N of the Act of 1960. In the instant case, my lord, please note down, it is relevant to take note of that for the state of Assam, there is no such amendment being made to the Act of 1960 or even to the provision of the Act of 1972. By way of an impugn notification, the state of Assam have permitted carrying out of the buffalo fights, modules, as well as bulbuli fight, birds fight, that to contrary to the provision of section 311M and so, notification dated 11/7/2011, as well as the provision of section 9 of the Act of 1972. In that view of the matter, the court answers the 2 points for determination as formulated above as hereunder. A, buffalo fight modules as well as the bulbuli birds fight, irrespective of being long tradition and practice in the state of Assam, cannot be permitted as is offense the statutory provision of the Act of 1960 as well as Act of 1972. The impugn notification permitting buffalo fights and bulbuli fights is contrary to the Act of 1960 and the Act of 1972 and according interfered with. Now kindly see number 1, impugn notification 27/12/2023 is set aside and quashed. Number 2, the court directs the state of Assam to ensure that the provision of the Act of 1960 and more particularly section 3, section 11M and N of section 22 is strictly enforced. In addition to that, state of Assam is further directed to take steps for enforcing section 9 of the Act of 1972. This court further observed and directs that judgment in case of A. Nagaraj as well as Animal Welfare Board of India are law within the meaning of Article 141 of Constitution of India. State of Assam is bound to conform with the law laid down in said judgment. Before parting with the record, this court finds it relevant to observe as regards submission made by learned so and so. Judgment passed herein should not preclude state of Assam to take appropriate action similar to what the state of Tamil Nadu, Maharashtra has taken. The court would not like to make any comment on the state submission as raised to something which is absolutely domain of the state legislature. This is a judgment. So there is a judgment, my lord, A. Nagaraj, where the judgment was totally it was prohibited. Now these three states, state of my lord Maharashtra, Tamil Nadu and Karnataka, they brought an amendment. And this was sent to president because otherwise it become repugnant with the provision of the cost 254. So they took assent of the president and the assent was given. So the constitution bench, while deciding the issue, said that no, there is no bar of these three states because they have taken maybe a central legislation, but the state has to take permission from the president to get assent of it. Accordingly, these three states has taken. So the court said there is nothing wrong, so they can go ahead. But in the state of Assam, there is no amendment, neither there is no precedent assent, which the court said we don't want to confirm, we don't want to comment on this. If you want, please go ahead and take assent of the president. That's why the court didn't want to enter into that area. So the ultimate SOP was set aside. Now what has happened? Why we have come to the court? We have come to the court because after the judgment which was passed by this court, we notified to all the concerned, to whom also. Please see now. Now, if your lordship looks into at page 59, see page 59. See from so and so, PETA India organization sent Thursday, January 16, 2025 to smacs@home@gmail.com. The Home and Political Department. That's a Home and Political Department. See, my lord, of the judgment at paragraph 41 also quoted. I am writing this so and so at paragraph 41 we quoted, and my lord will kindly turn to page 60. We quoted all the judgments. See the last line, 4 lines. Given the Honorable Court, High Court directive, we urge your esteemed office to take necessary directive to the district administration, police department, other appropriate or take strict and adequate measure to prevent all buffalo fights and bulbul for birds fight in Assam. We also request strong penal action be taken against any individual organizing illegal fight. Thanking you, so and so. Now, thereafter, my lord, please turn to page 61 also. Please turn to page 61. And please see that this is another letter because it is addressed to Morigaon, DC Morigaon, because normally we have seen that buffalo fight or Mojus is held either in Morigaon or it is held in somewhere in Nagaon district. Sipsagar, Morigaon, Dibrugarh, these are the 4 districts. Soraidio, these are the 5 districts where Bulbuli fight, the Mojus has been carried out. Now we have written at page 61, kindly see on top, PETA India organization to DGP, lordship got it, Mala? To DGP, so and so, Assam Police, Deputy Commissioner, Morigaon, so and so, so and so. Now CC, IGP, so and so, Assam Police, attachment 3 attachment, Annexure 1 High Court's order, dated so and so. So kindly see, I am writing on behalf of the people of so and so, illegal fight. So this has been narrated, how we moved the matter and how the court dealt. At page 62, on the top, as you are aware, the Honorable High Court in order quest and set aside the standard operating procedure. Lordship got it on 3 lines. As we are aware, the Honorable Gauhati High Court in an order dated so and so quest and set aside standard operating procedure dated issued by the state government so and so, so and so. So it was informed to all the now page 63, my lord. See page 63.
So you basically want a total ban. Kind of.
Until and unless.
Some amendment is done to
This is what-
the
you
SPT.
cannot violate the court's order. Why we came to this court? We will take appropriate steps, my lord, if necessary by a contempt, that's a different. How a subsequent cause of action has arose. Even then, lordship, why we came, that fight is going on. Kindly see. That's why we have come. Page 73. Page 73. Sorry, it starts from page 67. 67. See, this is an event which used to be held at Morigaon.
67.
67.
Okay.
67. All communication, my lord, which was sent to the authorities concerned about the event, we came to know. And to prevent this fight, kindly see 67. subject request to prevent buffalo fights and enforce the Honorable Gauhati High Court's directives. Please see this, smile.
Yes.
Now dated 17th of January 2026. Please see, my lord. Please mark, my lord, dated 17th of January 2026.
Yes.
Now, see, if you see at page 73, 73, please see. For a moment, please turn to 73. Now, we said
It is scheduled to happen when?
this is same. 13th of January, it has happened. 73, my lord.
So it has already happened.
Yes, no, absolutely no problem. What we are
Hmm.
saying, this has happened.
Hmm.
We have asked to suo motu register a case.
Hmm.
It could not have been happened, my lord. Why it is going on? In spite. So we have requested for by the suo motu FIR.
So 17-1, you wrote to this authorities.
Yes.
That intimating them that there is something going on,
Yes.
and then there may be a bullfight or whatever.
Uh,
Then in spite,
Logic.
I mean, so you have intimated it,
yes.
that, but in spite of that, I mean, that
It-
event
yes.
occurred.
Now, that's not only the case.
Hmm.
If you see at page 76,
Hmm.
again we ask, because register as suo motu, this is about Nagaon, my lord. Kindly see on 14th of January. This goes on 14th of January.
So it happened, I mean, it is occurring, it is
goes on.
occurring, it is
Yes.
occurring. Then
Now, my lord, all this starts from page 15. Sorry,
Page?
page 57. If your lordship can mark it.
57.
50, no, sorry. It starts from page 61, so 59 to 87. 59 is a communication which you have given to the home department.
Yes,
57 and 61 and to DGP and all those.
yes.
Then it started from 64 to 87.
Hmm.
64 to 87. Now, these are all communication. We told them take a suo motu action. Now, ultimately, on 2 occasions at page 88, because of our letter which we have issued to them
Hmm.
to take action against suo motu,
Hmm.
88 they have taken us, they have filed an FIR at page 88. Sipsagar. FIR?
So it was, I mean, it was filed on 16/1/2026.
Yes. And if your lordship kindly turn to page 92, another suo motu FIR was filed at page 92.
Hmm.
This is in respect of Nagaon.
Hmm.
Lordship got it?
Got it.
Now, now at page 95, this is again, my lord, FIR, these are FIR.
Hmm.
Now, these are the events, page 96. These are files that documented in January 2026. And if your lordship looks into the 5 events which has taken place at page 98, please see 98. We have made a list for the convenience of the court. Please see 98, my lord.
Yes.
See 1, Ahadguri district, Morigaon on 15th of January. Lordship got it. Garmoria district, Morigaon, that is 2nd. Number 3 is this district, Nagaon. Number 4, again Morigaon. And number 5 is at page 100, is Morigaon. Even in spite of the communication that is now what we want, notice may be issued. And in the meantime, we have asked that this, in pursuance to the constitutional bench judgment, in pursuance to the High Court judgment, how can they will not hold. This is what we are asking. Let them take instruction on this, my lord. Notice may be issued. And they will ensure, my lord, no buffalo fight will take place. They will ensure before the court. That's our prayer. I will not trouble with you. If your lordship want to see the judgment of Nagaraj and judgment of Constitution Bench, how the court relied by the learned single judge, it has been reflected. This is total violation of the, what the Supreme Court said in Constitution. My lord, initially, 2014, it was absolutely banned. They said that it is violation of the Act, 2 Act, Prevention of Cruelty and Wildlife Protection Act. So it was totally banned. Because, your lordship, there are two fights which was going on. So far as Maharashtra, Maharashtra is a bullock cart race. In Maharashtra. And in Karnataka is Kambela, that is a race, that is a buffalo race. There is no directly impact two buffaloes fighting each other.
They are not fighting together. I mean, there is a
Yes.
race.
Yes, there is no chances of any injury.
Mm.
And 3 is, my lord, Jallikattu.
Mm.
This is also, your lordship, is like Spain, is a bullfight, human and bull, where you put a rat and it's like a Spain, like that. Tame the bull. But there is no direct. Here there is a difference. That's why we have given a lot of photographs. So the court has taken note of it while deciding the issue. And these 3 states, my lord, while deciding by the constitution bench, because that
But
is
why
what-
do you need an interim so urgently?
because then today, my lord, April, what happened this month?
But in the, I mean,
Interim, what we are saying?
No,
We are saying- we are-
in Rongali Bihu, I don't think
No, their flights, my Rongali Bihu, yes.
Mark
Of
Bihu, they
course.
have it.
Mark Bihu also, even after that, my lord, it goes. What I am saying, my lord, they will ensure, the state government will ensure compliance of the High Court's order. They have to comply. It has been written to the highest authority, my lord. It is them who has to prevent. It is not that it is not informed by virtue of the judgment of this court. The state government was present while the judgment was passed, while it was heard.
So, yeah, I mean, that SOP has been set aside.
Set aside.
Already set
Set
aside,
aside.
and state government has strictly complied with the order of this honorable court, directive of this honorable court. my
How
lord.
this fight is
My
going
lord,
on?
the lordship has already seen, my lord, the FIRs have already been raised and
Yeah, correct.
can take instruction. What is the outcome of, what is the status of?
No, no, if you are saying that
My-
like state government is complying with the orders,
My lord,
then there is no, there should not be any issue
violation.
in passing an interim order, staying all bullfights.
My lord, already lordship.
No,
lordship
I mean,
can
don't,
pass.
talk into
Lordship-
different these things.
That's not on, my lord, lordship may pass because.
No, what
it's
I'm
not
saying is,
violation.
what I'm saying is that since he's asking for an interim, so
No
uh,
prayer for interim here, my
No,
lord.
we have paid. We have paid.
Which is
We
the
have
prayer.
pending disposal, maybe please to direct no buffalo fight take place and to penalize the
Yes,
organization.
my lord, lordship can pass it because
no, I mean, before passing it, we'll have to take your instructions or whatever,
lordship,
your submission.
I
So-
can take instruction.
So you can take instruction, in the meantime, you stop it.
Eh,
I mean,
no,
there should
no,
not be
because
any bullfight.
We are bound to obey, my
Correct, and I mean, we can see that we appreciate that you have filed couple of affairs and all,
lordship.
but that may not be sufficient, so you'll have to
Maybe.
take certain more actions,
My lord.
active actions.
My lord, maybe
So these are
the-
issues, I mean, this may be
Vigilant-
happening for
uh,
many years, many years.
Already-
But it's, I mean,
already set aside, already court has given the direction.
court has,
After
given
that,
a-
we have
court
stopped, my lord.
court has considered the
Yes,
matter.
yes, my lord.
considered
Yes,
the
my
matter.
lord. Until and unless some amendments or, my lord, as done in the other 3 states, my lord.
So you
And
can, you
have
can't,
stopped, my-
do, I mean, keep on doing it in violation of this thing.
My lord.
Mr. Das, I will pass the order after looking into,
Yes.
let me go through it because it's a bulky document.
No, absolutely. no.
So I will pass an order.
Yes,
I'll pass an order and pass the order today itself.
yes.
But let me go through, I mean,
No, no.
whatever is there
Yes, yes.
in the, I mean,
Yes, yes.
I'll take, I'll,
Yes.
because otherwise you need to consume a
My
lot
lord,
of time here.
I would not have pressed the interim. Why I'm pressing, there is a judgment of the constitutional bench. There is a judgment of this honorable court. My learned friend he says, okay, we are respecting the judgment of this honorable court. Number 3, if you are respecting this judgment of this honorable court, it was a duty of the state with great respect that this fight should not have been happening. What the Home Department should have said, they should have notified to all the district, so look here, this is a judgment, please follow the judgment. Whoever organizing is there are SPs, there are deputy commissioner of each district, why they have not complied?
I'll take
That's the
instruction.
whole
my lord.
issue, my lord.
What steps have been taken
Yes.
by the state after the judgment, man?
You are appearing for all the respondents?
two respondents are there, my lord. I am preparing for statement. Yes, ma'am.
So we'll pass an
Yes.
interim, appropriate interim order. Okay, we'll pass an appropriate interim order. Only thing is that I just want to go through the judgment.
Lordship.
I went through it, I mean, but
And
I
if
didn't
you
get
notice
sufficient
on
time
the
to go through it.
judgment Of the Supreme Court, of the Constitutional Bench, we'll just provide one copy.
Mm.
Because already it is there.
That Nagaraja case or
Yeah,
something.
the Nagaraj and the Constitution, where they want to review of the order of Nagaraj,
Mm.
review of the order
Review
by
of the
the
order,
Constitution Bench.
Mm.
They said and they decided, yes, these three states, they have taken the permission. Amendments has been sought for. It has gone for presidential assent.
And
And
they-
yes, it can go ahead. It
Mm.
doesn't contravene with the Central Act.
Mm.
Yes.
It is not repugnant. That's the whole issue, my.
Mm.
It have reflected. all this.
Judgment of this honorable court also, my lord, already discussed all these things, and that steps is, my lord, it is, my lord, given the, my lord, liberty to take steps as done by the three states, my lord.
Understood. Mm. I think it will be better for me to, I mean, just go through the, I mean, if you have the case, I mean, the
Yes,
other
yes.
case,
I
you can,
will
you can
give you-
pass it on to me.
I'll pass it on two judgments. One is the Nagaraj in 2014. Then next is 2023, no? That's judgment 2023 Constitutional Bench judgment that I will provide with these two judgments.
Animal welfare board.
2023 9 SCC, page 322.
2000?
2023 9 SCC 322. And the earlier judgment was, that was 2014, sir. 2014 7 SCC 547. That was the first judgment. 2014 was the first judgment.
Then
but
it went to
totally
the.
it was banned.
Mm.
Then thereafter, these three states, they amended.
They have
And they
taken
took
the
short
consent,
notice at the proceeding
they have taken the
precedent.
consent of the president.
That's
and
why
like
they
by-
filed a review there.
Mm.
And that order was passed.
Mm.
Here, when the SOP was issued, there is no act amending the act.
Mm.
So the court said that you can't. This is a
It
violation.
is a violation of the act, so you can't do
Nagaraj
it. If,
It
if-
stands.
if you want to, I mean, if you want to take the consent, you have your liberty, you have the
You
liberty
can
to
go
do it.
ahead.
But they
Take the
haven't done so,
presidential
but they
assent.
haven't done so. So if anything is happening now, this is in violation of
Yeah,
the act.
correct.
Violation of the
I will
act.
provide with.
And state hasn't taken any proactive action,
Yeah, correct.
issuing any notification or any order or rule, whatever. It was not distributed in the state. And the only thing is that your organization is
Now,
doing some
while the
communications.
SOP goes, SOP has gone. They have to take the permission from the president itself. The notification, if they come up, let's say, they come with a notification order, that will not suffice. Because this is inconsistent with the Prevention of Cruelty Act and with this.
But that has been already clarified. I mean, that has to be amended.
I have seen all these three states where there was an amendment which was brought for and the Supreme Court said we can go ahead, was on a, they did not, this animal doesn't fight each other. So there is a chance of, there is an injury which has taken place.
So, so in that context, I mean, that amendment was done and some permission was
Yes,
given.
these are all
Certain
fight-
limited
there is
permission
no
was given.
fight between two animals.
Mm.
It is a race.
Correct. So now,
But
now,
given
now,
that
now, now,
it was-
if the state government can prove that there is no injury
No, that's
happens
a
there,
different-
this thing though,
My
then
lord,
yeah,
it
we
is-
need some,
it
that's a
is-
different.
It's a domain of the legislature. They can do it. That's what the court said. We don't want to comment on the issue.
My lord, after passing of the judgment, my lord, the state government has completely put ban on, my lord, fighting. If, my lord, some person is doing as my. my
Banned
lord,
by
target-
what? How have we banned it?
No fighting is
No, no,
allowed.
how have we, no, where is the notification?
My lord, further notification, I'll have to take steps.
No, no, no further notification. I'm not asking about further notification in terms of the judgment of this
My
court,
lord,
whether in notification has been issued.
that, my lord, I'll have to take steps because right now, my lord, just for the first time. it
No,
is
you
done.
have stated that there is some, some ban has been done. Where, how the ban has been done?
My lord, instruction, my lord, over telephone that now no more, my lord, fighting is allowed
No,
by
no,
the
no, what the
authorities.
court is asking is a specific and very simple question.
My lord.
In terms of the judgment passed by this, by a coordinate bench of this court, whether you have taken any action, whether you have issued any notification,
My lord.
whether you have, I mean, intimated all over Assam that
Ma-
this is not supposed to be done,
Ma-
whether you have done that so.
My lord,
That you haven't done, Only thing is that you are filing some FIRs
We
wherever
can
it is
say, my
happening.
lord, we can't, because I don't have the instruction right now, my lord. Lordship, maybe
they-
please to give me some time, my lord, I'll take instruction and I'll place it before your lordship.
And your lordship will see, FIR has not been filed by them. It is because of our that suo motu has been taken. Because of the High Courts and Supreme Court judgment. If that be the case, then why this
So,
fight is going on?
this
exactly.
last, I mean, this is an important social issue. This is
Yes.
happening for a long time, and like it may, I mean, obviously it's a tradition going on, customary tradition going on. But since there are certain things have come up now,
My lord.
you need to take some action.
History,
Yes,
my lord, history, tradition, if your lordship looks into judgment of
These,
2000.
I mean, tradition,
history
also,
and
these are,
tradition-
these are dynamic words.
But
I mean,
history-
it
no,
keeps
no.
on changing.
This particular has been, my lord, discussed by the Supreme Court in 2000.
Yes, yes, yes.
History and tradition.
Yes, yes. So history and tradition, but something is not good for the society cannot be allowed to go on.
That's all.
That is
That's
the
it,
thing.
my lord.
My lord.
So I'll pass the order.
Your lordship,
I'll
lordship.
pass the order. I'll just go through the cases they have referred to. Those cases are,
My lord.
if you are, if those are available,
No,
is,
it's available.
yes, is pass it
No,
on
it's-
to,
it's
pass it on to the court master. I mean, if you can give it before the lunch time, it will be better, because from tomorrow it's a holiday. So I would like to pass the order before.
20 minutes that will be provided
Okay,
and giving the most important paragraphs of 2014.
that will be great.
That paragraph also.
That will be great. That will.
My learned friend from Delhi has some her names.
Okay.
If it is reflected.
Okay. If, take her name also. I just give the names.
I'm taking of this.
Lordship is fixing the date or, my lord, so that I can take instruction.
No, you
before-
take, I mean, it will be listed after the vacation.
My lord, my lord.
By the, you take the, but some interim order will be passed, that
Madam.
I will look into, I mean,
Madam.
what exactly the
Lordship.
Supreme Court has said. I have gone through it yesterday a little bit, but I could not,
Yes.
I didn't have sufficient time to go through it.
This High Court,
provided.
so my lord, pass the order not to no further, my lord,
Correct.
already, my lord. Direction has already been
Ma'am.
given by the, in earlier order, my lord, by this honorable court. Lordship is passes any order, my lord.
I have deeply observed.
I'll do that.
Leftover from yesterday, the second.
Yes, yes. Anything has come, Mr.
Lordship, I asked the IO2 for any instruction, Lordship, but Lordship, as per instruction, Lordship, it is in investigation stage, Lordship, and nothing else, Lordship.
So what about, he is inside the jail for now last 76 days, right?
29 today.
79 days.
I leave it to Lordship.
I mean, and it's a 90 days mandate, right? So investigation is still going on. That's what they're saying.
Moreover, it is not a case of 103, it can be case of 105. Culpable homicide not amount to murder, knowing there is no intention to kill particularly, then why it will come under 105?
But there is a concern also, whatever, I mean, whenever some incident happens, I mean, this kind of, I mean,
Emotionally and angrily, they attack the.
we have, I mean, this court has also privy to so many incidents happening all over Assam.
Not only all over India, I don't know.
And
outside.
I'm not talking about India, but
Yes.
like in Assam, I mean, some incidents really, I mean, some ghastly incident happened
Yes, yes.
involving,
And not only they kill the driver or the owner minor, but also they destroy the car. They burn the car also.
On the day of reopening, it will be 90 days, Lordship. Today is 78 days.
Hmm.
On the day of reopening on 20th, it will be 90 days, Lordship.
yeah, let them go on bail.
Hmm?
And these are, Mr. Parasar, these are small incidents. Small incidents mean, I mean, like for the purpose of investigation. For the purpose of investigation, nothing much to be done in this case. Everything is there. So, I mean, still, it takes so much of time. Right. Heard Mr. R.P. Sharma, the learned senior counsel, assisted by A. Rasid, the learned counsel, appearing for the accused applicants. Also heard Mr. P.S. Lawkor, the learned APP for the state. This is an application under section 483 of the BNSS, praying for bail of the accused applicants. In connection with Kokrajhar PS case number 12/2026 under sections 103 in bracket 2 stroke 109 in bracket 2 stroke 117 in bracket 4 stroke 118 bracket 2 stroke 324 bracket 5 of BNS comma 2023 in bracket you can write GR case number 26 stroke 2026 full stop. Next para you write an FIR was lodged on 21/2026 by one Baranda Vasumutari before the Kokrajhar police station, inter alia, that on the evening of 19/1/2026, at about 7 p.m., his son-in-law, Sikhna, Sikhna, Sikhna Jhawlao, JWHWLAO, Jhawlao Bismith, BISMITH, Bismith was driving his own Scorpio vehicle, bearing registration number AS01-GK-9152, returning from his work site with goods, full stop. That when, as full stop, don't put full stop, you write semicolon. That when he was about to reach Audang Bazar, AUDANG, Audang Bazar, his vehicle met with an accident, resulting in the death of an Adivasi person on the spot, full stop. Following the accident, local Adivasi people allegedly attacked the vehicle, assaulted his son-in-law, who died on the spot, while two other persons were later rescued by the police. Next para. On receipt of the FIR, the police registered Kokrajhar PS case number 12/2026 under the aforementioned sections. Full stop. Next slide. After the preliminary examination, investigation, the police arrested the accused applicants on when they were arrested,
2021-2026.
arrested on 21/2026. And since then, the accused applicants are behind the bars. Full stop. The learned senior counsel appearing for the accused applicants submits that the incident occurred in the heat of the moment and without having any intention to kill the victim without having any intention on the part of the accused applicants to kill the victim at that kill the victim, full stop. He submits that though investigation is supposed to be going on, nothing concrete has come out till date, and the accused applicants are behind the bars for last 79 days. Full stop. In view of the aforesaid, he submits that don't write in view of the aforesaid, you write he submits that the accused applicants are local villagers, and they came to the spot when the accident occurred and occurred and the accused applicants are in fact not actively involved in the incident of killing of the victim, full stop. He submits that the accused applicants shall cooperate with the investigation in the event of their release on bail, full stop. He further submits that the accused applicants are mostly young people within the aged in the range of 18 to 40 years. And since their detention behind the bars, their families are immensely suffering. In view of the aforesaid, the learned senior counsel submits that the accused applicants should be released on bail. The case diary in the instant case has been produced before this court.
The case is not available.
Not
Lordship.
available.
It is on motion stage, Lordship.
Hmm?
It is on motion stage, Lordship.
No. Then you write, then you write like this. Your earlier bail application was rejected, no?
Yes, rejected on my lord.
On? Okay, got it.
Earlier
uh,
withdrawn prohibited.
The accused, the accused
That was after
applicants,
Earlier 2 times it was withdrawn.
Huh?
Lordship. Earlier 2 times it was withdrawn.
Two time we don't want rejected.
once rejected, once withdrawn.
Yes.
Right like this, the accused applicants had earlier also preferred a bail application. Wide bail application number 320/2026. On consideration of the case diary, the same was rejected by this court by its order dated 24/2/2026. Thereafter, the accused applicants had filed another bail application, that is bail application number 781/2026, which was withdrawn. Which was withdrawn by two bail applications filed over.
Twice it was written because the time was very short, my lord. On the 35th day, they are moved. That's why.
Then you read, last time क्या लिखा? No, उसको बोला two other bail, you write two other bail applications. First bail application लिखा ना rejected. उसका बोला two other bail applications. That is bail application number 781/2026 and 711/2026 were filed. However, the same were withdrawn. Full stop. The learned Mr. P.S. Lockhart, the learned APP appearing APP submits that the investigation in the matter is yet to be completed, and therefore he opposes the bail, opposes the granting of bail to the accused applicants at this stage. This court has considered the submissions made by the counsel appearing for the respective parties. Full stop. In consideration of the fact that the incident actually happened
On 19/1/2026.
The incident actually happened on 19/1/2026 when the victim in the instant case, when the victim met with an accident and an Adivasi person died on spot. Died on spot, comma, and thereafter the crowd gathered there. And the crowd gathered there mostly of the Adivasi community, including the accused applicants. At the heat of the moment, attacked the person who had committed the accident, and thereby killed the killed the killed the son-in-law of the informant. And also taking into account of the fact that the accused applicants have been languishing in the judicial custody for last 79 days without the 79 days, and the investigation is yet to be completed. This court is of the considered opinion that at this stage the accused applicants should be granted bail. Full stop. Therefore, it is directed that the accused applicants shall be released on bail on furnishing of bail bond of rupees 20,000 each, with one's surety of like nature, to the satisfaction of the CGM Kokrajhar, subject to the following conditions. Right, first, that the accused applicants shall cooperate with the investigation in the instant case and shall make themselves available as and when required by the investigating officer. Full stop. That the accused applicants shall not try to influence or induce any witnesses that may be involved, that may have any connection in the instant commission of offense. In terms of the aforesaid directions, the instant bail application is disposed of as allowed.
May I please, your lordship? 483 bail application, lordship. Lordship, FIR was lost on 12/3/2026, lordship. Lordship, on the context that the complainant's daughter went missing, lordship, and subsequently the section 87 was attributed in this case. Upon registering this case, lordship, the investigating agency, lordship, will find in my petition on para 2, page number 3, lordship, the present petitioner was arrested from Patwadi, Haryana, lordship, upon a transit remand, lordship, for 3 days, lordship. Thereafter, he was brought before the court of CGM Kamrup Metro on 24, lordship. That will, lordship, will find on page 5, lordship, on my petition, and the forwarding is on page 27, lordship. The victim girl was recovered along with the petitioner, lordship, in Haryana, lordship. That, lordship, will find on the reason of arrest on the forwarding, lordship.
You first tell me what is the offense. Tell me what is there in the FIR.
Lordship, in the FIR, lordship, the complainant has in page 15, lordship, type copy. May I read, lordship? Most respectfully begs to state that on 6/3/2026 at around 4 p.m. my daughter Rinki Begum, 18 years, was missing from Narengi. It needs to be mentioned herein that the girl is suffering from mental disorder. Therefore, you are requested to rescue her, Lord. This is the FIR, Lordship.
Then what happened?
Then, Lordship, the investigating agency
Hmm.
has after
He was recovered from where? Bihar,
Haryana, Lordship.
Haryana.
Apune search operation, Lordship.
So we'll issue notice in this.
Yes,
you know.
my lord,
We
16 days
will-
today only, my lord.
Huh?
Today is
You-
16
you-
days
you
and my lord,
bring-
they are
bring
also
16.
from my lord Haryana, my lord. And section is 87, kidnapping and abducting a woman, my lord. At this stage, my lord, query may be solved for my lord.
That heard Mr. D. Mehdi, the learned counsel appearing for the accused applicant. Also heard Mr. K.K. Boysa, the learned APP for the state. This is an application under section 483 of BNSS 2023. Praying for granting of bail to the accused applicant in connection with Nilmati PS case number 43/2026 under section 87 of BNS 2023. Full stop. The case, an FIR, a missing FIR was lost by the father of the, by the mother of the victim girl on 7/3/2026, before the officer in charge Nulmati police station. In after the preliminary investigation, the police recovered the girl from the state of Haryana. From the house of the accused.
Yes, Lordship.
Hmm?
Yes, Lordship.
Haryana from the house of the accused person, supposed to. Thereafter, the police arrested the accused applicant on 23/2026, and since then he is behind the bars, full stop. Let the call for the CD, let the matter be fixed on
22nd, my lord,
22nd April,
22nd.
Deeply obliged.
22nd.
17.
Yes. My lord, I take your lordship affair. One girl, small girl was found in the market, my lord, loitering. So this accused person has asked a question her and where you will go, where from you have come. In the meantime, my lord, in the FIR it says it is suspected that he has brought this girl and to allegation of this trafficking has been alleged against me, my lord. So I am arrested, my lord. I'm 15/3, my lord. So, my lord, what I pray, my lord, almost 1 month CD may be called from Gorchuk, my lord. In the FIR litigation that is suspected that there is a conspiracy.
Right, I heard Mr. SC Biswas, the learned counsel appearing for the accused applicant. Also heard Mr. KK Boysa, learned APP for the state. Then you write, this is an application, huh? This is an application, you write. Then you write, an FIR was lodged on 43/2026. 2626 to the effect that an information was received from the local police of Achalpara Gaon to the effect that one minor girl was found along with one person, namely Jahangir Alam of Buluka Bari area, full stop. On being questioned by the local public regarding the identity of the minor girl, it came to the light that the minor girl, namely X of Bhutboria Bazar, PS Gorchuk, Guwahati was taken from Bhutboria Bazar by the accused person on the pretext of false promises. Full stop. The accused person, next, you take it from page 13, if there is some, यहाँ से ले लेना, 13 suppose. The accused person was arrested on 15/3/2026. Right after filing of the FIR, the police registered the case. Police registered Soigaon Police Station case number 55/2026 and the accused person was arrested on 15/3/2026. Call for this, call for the CD, let the matter be fixed after the entering the vacation.
My lord, may I pray it or if possible, 24?
24, not many matters are being fixed.
23, my lord.
Okay, 24, 20,
Of right.
20, no, 23, make it on 20, let the matter fix on 23rd.
My lord, this is the related to NDPS commercial quantity, my lord. Charge already been framed, my lord.
Hmm?
Call for TCR, my lord.
Charge already framed.
Yes, my lord.
Okay. You read Mr.
KM Hassan.
KM Hassan. KM Hassan, learned counsel appearing for the accused applicant, also have Mr. PS, KK Boyson, learned AP for the state. This is an application under so and so, only thing, under so and so. Then the case relates to recovery of how much?
My lord, 900 gram Yava tablet.
900 grams of Yaba tablet.
About 900 gram.
About 900 grams of Yaba tablet from the position, your position?
Mild.
From the position of the accused applicant. The accused applicant was arrested on
22, my lord.
22
August 25. 22 August 25.
22 August, 22/8/2025. Charge sheet in the instant case has already been filed and the case is pending before.
Special
Special,
NDPS case number 1/26.
no, case pending before which
Special
court?
Special Judge Sri Bhumi.
Pending before the special judge Sri Bhumi, full stop. Registry to call for the scan copy of the TCR in connection with the instant case from the
Special NDPS
Special
case number 1/26.
1 so and so 26 when from the special, from the learned special judge come session judge Sri Bhumi.
Sri Bhumi.
Let the matter be fixed after the view vacation.
Date में
Okay,
Any date,
then, 28th
Mile.
April.
Obliged.
Let the matter be fixed on 28th of April.
19.
May I please, your lordship? 483 bail application, lordship. Lordship will find the FIR on page 16, lordship.
Page 16.
Page 16, lordship. Here, lordship, on 24/3/2026, upon a search operation, the present petitioner was detained and suspected contraband ganja of total 2.223 kgs were recovered from the possession of the petitioner.
Okay, we'll call for the CD.
Lordship, here I am taking the ground of, lordship, illegal detention, lordship, beyond 24 hours.
Okay, we'll beyond 20 hours, we'll have to confirm from the CD.
Lordship,
How will I get to know?
lordship, on FIR itself, lordship, if on FIR and forwarding, lordship will find, lordship.
Hmm.
Lordship, on 20, may I read the FIR, lordship, from the beginning, lordship?
1 second, 1 second. So FIR was filed on
FIR was
25/3/2026.
here.
And it was filed before the railway station, before the OC railway station.
Yes.
Then, I mean, you are detained when?
I am detained since 24/3/2026.
Hmm?
I am detained since 24/3/2026.
It is to inform you that on 24/3/2026,
Yes,
Tinsukia.
on 19:05 hours, lordship. 7/5.
And when you were produced?
I am produced on 26, lordship. That is on forwarding, lordship, page number 23, lordship.
But as per this, you were arrested on 25th, 3/2026, 9 PM.
In the
Lordship.
forwarding method.
Lordship, as per the FIR, I have been detained since Lordship 24 itself, Lordship. And
That
Lordship,
has to be confirmed, that is to be confirmed let him take instructions of this.
Immediately after vacation.
Immediately after the
Immediately
vacation.
after reopening. ma'am.
We may have a case, I mean, but that has, instruction has to come, let's see.
Yes, ma'am.
It's heard Mr. D. Medhi, the learned counsel appearing for the accused applicant, also heard Mr. P.K. Buster, the learned deputy for the state. This is an application under so and so. The case relates to recovery of
Ganja, Lordship.
2.223 cases of ganja from the possession of the accused applicant while he was traveling by rail by a rail at Kamakya
Railway
station, at Kamakya railway station, full stop. The accused applicant was arrested on arrested on
Arrested on
25/3/2026 at 9 PM, full stop. Since then, he is behind the bars. Call for the case diary. Let the matter be fixed on 2020, let it be on 23rd only, 23rd April.
23rd, Lordship, I have a problem on 22, Lordship.
Okay, 22 April.
April.
Your Lordship, offense relating to commercial quantity of NDPS substance, Lordship. So at this
So-
stage, record may be called for.
Charges submitted.
No, not charge sheet submitted, Lordship. Investigation.
Heard Mr. A.J. Ahmed, the learned counsel, appearing for the accused applicant. Also heard Mr. P.K. Boyster, the learned APP for the state. This is an application under section 483 of BNSS, 2023 for granting bail to the accused applicant. In connection with Sri Bhumi PS case number 17/2026, registered under section 22 in bracket capital C/29 of NDPS Act 1985, 1985, full stop. The case relates to what was the quantity of
672 grams of heroin, Lordship, from the FIR name accused person. 672 grams of heroin from the FIR name recovered from the arrested accused person.
he is from his position.
No, not from this present petitioner. He was arrested on the basis of confessional statement of the arrested.
Okay, who is the prime accused?
Prime accused is, Lordship, two persons were arrested.
Hmm.
One is Sairul Ahmed and another is Kajol Uddin.
Okay, the matter relates to recovery of suspected heroin amounting to the suspected heroin weight about 672 grams from two persons, namely Sairul Ahmed and Kajal Uddin. Full stop. After their arrest, they have implicated. What was the implication exactly?
I was arrested on the basis of that. They have disclosed that they were supposed to deliver it to me.
Okay. With the present accused applicant is arrested on the basis of confessional statement of the aforesaid two accused persons that the quantity so recovered was supposed to be delivered to the present accused applicant. Full stop. Call for the CD. Let the matter be fixed on 28 April, 28 April, 28 April.
Problem. 21.
Me please, my lord. 21B, my lord. Under section 21B NDPS Act, my lord. Recovered heroin, my lord, without container, my lord, 13 gram.
How much?
With container, 13, only 13, 13.
13.
13 gram, my lord, heroin, my lord.
Oh.
With container, my lord, 25 just. But after container, my lord.
17 days today, my lord.
Hmm?
17 days today. Today is 17 days.
19 days, my lord. Arrested on.
Okay. Heard MS so-and-so, the learned counsel appearing for the accused applicant. Also heard Mr. KK Boyso, the learned APP for the state. The case, then you write, this is an application under section. You can take it from here, the application that from the cost title you take it. Application under so-and-so. The case relates to recovery of about 13 grams of suspected heroin from the possession of the accused applicant. The accused applicant was arrested on
2020.
23,
2026.
okay, 2026, and since then he is behind the bars.
This thing is 20,
Huh?
not 23,
2026, right?
Yes,
Yes. Then you write, call for the CD, let the matter be fixed on 24th of April.
Not 24, my lord. Kindly list the matter 21, my lord.
21, it will be difficult, madam.
My lord, 20.
Then 28?
No, my
28 of
lord,
April.
23.
23.
23.
No, there are a lot of matters fixed on this date. I mean, if your matter is listed also, I mean, it may not be able to take up so
20
many matters in this. So
24,
28,
25, my lord.
13 days only, 28. It's fine, 28. Wait for some time.
Your lordship, intermediate quantity lordship, he was arrested on 5/3/2026. As on today, lordship, 35 days in custody.
Okay, wait for some time, Mr. Azad.
35 days on quantity.
Heard Mr. A. Ahmed, the learned counsel appearing for the accused applicants, all applicant also heard Mr. KK Busho. You are K or KK Busho?
My lord K.
Only K, not Kumar.
No, no.
Okay, Mr. K. Busho, the learned counsel, learned AP for the state. Then you write, this is an application under so-and-so. Then you write, the case relates to recovery of 13.1 grams
Which so?
of suspected heroin. And then you write, don't write 13, you write 12.4 grams of suspected heroin from the possession of the accused applicant. Call for the case diary, let the matter be fixed on 28.
Let me prior to the, because otherwise, lordship, that is, he will be getting to that statutory period, lordship.
How many days are there?
His lordship 35 days as on today, lordship.
35 days. 35 days.
Can it be on 23 or 24 any day?
Okay, let it be fixed on 23rd.
Okay. 23. Then okay, probably records will be required that commercial quantity is there, but only thing is I'm pointing out lordship here, lordship, in addition to that, ECR lordship, one report may be called for that lordship here, what happened, husband of the present petitioner was arrested initially on the basis of FIR. And subsequently, police filed lordship that submitted one document that for section 48 notice was served to the family member. There was a thumb impression of the father, they say. Then lordship, father filed an application that this document is manipulated. And accordingly, a report was called for by the learned session just regarding that FSL lordship, that thumb impression. Other document is also there, seizure list also I have enclosed. There is also apparent manipulation is there. So at this stage, lordship, I am saying that report regarding the 48 notice where it was sent to FSL, that report may be called along with.
It was sent to the FSL?
FSL already report received as per my instruction.
Okay, FSL report regarding the thumb impression.
Okay. That,
Okay. Heard Mr. A. Ahmed, the learned counsel appearing for the accused applicant. Also heard Mr. P.S. Lawford, the learned APP for the state. This is an application under so-and-so. Then you write. So what was the quantity and all?
Here, lordship, quantity, lordship will find at page 30, lordship.
Page
30.
30.
This is the part of the charge sheet, lordship. 2000.
It's from your possession only.
It is alleged that from my house.
Okay.
2000 numbers of Yaba.
The case relates to, relates to, recovery of
2000 numbers of Yaba tablet.
2000 numbers of Yaba tablets from the house of the accused applicant. Full stop. The accused applicant was arrested on when,
10/25.
huh?
18/10/25.
18/10/2025, and since then he is behind the bars. Full stop.
She, Lord, a lady.
Huh?
She. She is a lady, Lord.
Oh, C, C is behind the bars, okay? Then you write, call for the, charge sheet not filed, no?
Started
PCR.
file, Lordship, PCR will be.
Raised to call for the scanned copy of the PCR in the instant case along with the FSL report
Lordship,
regarding,
may kindly say page 65.
FSL report regarding page
65.
65, where is that?
Last portion, your Lordship, find that CGM was directed to conduct an inquiry regarding that, Lordship. Then thereafter, that was sent for FSL and report as per my instruction already received.
Okay, so like you are stating that like there is an FSL report.
Yes.
So, also call for the, FSL report,
In connection with
regarding the thumb impression of the father,
Yes, father.
of the father of the accused applicant.
At 1648.
If the same is, available. Let the matter be fixed on 23rd.
24.
Here, the petitioner was arrested on 12/3/26, on the strength of non-deliverable warrant of arrest issued against him, on by order dated 14/3/2018. Yeah. Thereafter, initially he was arrested in the case, and thereafter he appeared and so on. After charge sheet was filed, but but after that he defaulted, my lord, because during the COVID, my lord, his counsel instructed him that court was not functioning. And in the meantime, his counsel also expired, my lord, that I have stated, my lord.
But it's a long time back.
Yes, my lord. Counsel also expired, he could not maintain proper communication also with the counsel. So thereafter, now after this warrant was issued, then he was arrested and we came to know that his.
The
about
last
the
order is also
state.
not enclosed,
So
Lordship.
otherwise, well,
Last order is also not enclosed, Lordship. Only the 39/2024 order is being enclosed.
no, initial order I have an issue, no? That is there. 14/3/20, that NAW was issued. Only because his counsel expired, my lord, that is the reason actually he could not get information that what the status of the case. Now he will appear, my lord, it is allowed to.
What is the present status of?
He is arrested, my lord. The trial is on
He's arrested on when?
12/3, my lord.
Huh?
12/3/26.
12/3/26. Last order was when?
Here the annex is annexed to 5 page 28 is the
No,
last order.
39/2024.
Long
30, 20, 26, 24 it should be.
It
Page
is
28.
24, huh?
Page 28.
That is 24.
Yes, ma'am.
during these 2 years, what happened, Lordship, we do not know, Lordship, what order passed, Lordship, why?
No, he was arrested thereafter, my lord. That's why he was produced also, my lord. There, my lord.
Now, after
At
39 to, no, when was he
Page
arrested?
25, man. Page
You
25.
you are saying 12/3/2026.
my-
Yes, Lordship,
yes.
he is arrested on
Page-
15.
Page
No,
25, my lord.
I mean, what happened after 39/2024?
My lord.
So in view of the above, considering that it is an all pending case. So and so, no, before that. Perusal of the record reveals NBW has been issued several times against the accused person who, however, it has not been executed so far.
12/3/26 order, may kindly please, at page 25.
Hmm?
That will keep clear, my lord, that he, at 12/3,
Page 25.
page 25, my lord. That is the last order. So that order shows that he was arrested and produced before the court below, my lord. After in view of the NBW issued against him.
Forwarding from listening.
Then, no, 23 to 1.
Forwarding from listening.
You have been arrested after 8 years.
I already said it, my lord, they said that the council expired, my lord, due to that.
No, council expired,
So
but,
that is
but,
the- anyway, COVID was also going on.
but your matter is going, COVID is long time.
That is the COVID
Mr.
also was in the meantime was going on, and thereafter in the. they
Let
could
us-
not
let
know
the-
that this ex-
Let the TCR come,
Yeah,
call,
yeah,
come
I
for,
mean, now
for us,
charges
because,
also.
because Lordship,
Trial-
Mr.
Trial
Hazarika,
of
well, let the TCR come, we'll see the conduct. I mean, he was, I mean, this is not the way, I mean, he is not there for 8 years. His matter is going on, he knows.
He is along with another accused also there, but he not only.
Correct, another accused, we are not
He is also
concerned.
not my, not even.
Another accused, Mr. Hazarika, we are not concerned, but we are concerned with the person who is before this court.
Yes, ma'am.
His conduct
So
seems to be
doctor,
not
he-
good. And this, your, I mean, after considering your conduct, I mean, a sessions court has already rejected. So this is something, I mean, this court has to also take into
Not
account.
only that is the reason because.
So that is why we are calling for the TCR. Let the matter be fixed after, immediately after the vacation, and we'll see.
No
We'll see.
purpose to be
Hmm?
served now.
Hmm?
No purpose served, my, we will appear in a trial, my lord.
No,
Trial is also started, my lord.
he will appear in the trial, but thing is that, I mean,
Conditions may be imposed, my lord.
but thing is that only because that he will be appearing in the trial, he will not be, I mean, this trial would have been completed by this time probably. You are, I mean,
Yes, ma'am. That is
his,
true, my lord.
I mean, so much of judicial time has gone.
So this
Now, who
COVID
will be
period also,
accountable?
my lord, that-
Who will be accountable for that?
COVID period also gone and even council also expired. ma'am,
COVID
so-
period, COVID was there in 2020 till
Yes, that's true.
2022.
And council also expired, madam. That
Council
also-
expired, I mean,
Legal
he should have contacted.
Yes, that is true. That is the fault, but I have.
Now, we'll see the, I mean, we'll not allow this bill at this stage. Heard Mr. A.I. Hazarika, the learned counsel appearing for the accused applicant. Also heard Mr. P.S. Loco, the learned APV for the state. This is an application under, you said, write all these things. Then you write, the accused applicant has, had approached the session judge, Sunitpur, Tezpur, by filing an bail application. The same was considered on 12/3/2026. 26 by the aforesaid learned session judge on the ground that the accused applicant had defaulted in his appearance, and therefore NBWA and PNA had been issued against him, and he was arrested on the strength of the NBWA after about 8 years, taking into account the conduct of the accused applicant, his bail application was rejected by the learned session judge Sunitpur, full stop, Tezpur. Registry to call for the TCR in connection with sessions case number 80 scan copy of TCR in connection with sessions case number 80/2026 26 pending from the court of the learned session judge Sunitpur, Tezpur. Let the matter be fixed on 21st. You were there?
20%.
21st of April? We are fixing on 21st of April.
May I please, your lordships, this my lord, 482 petition, my lord. In this case, the kindly have a look at page, my lord, page 9 of my petition. Page 9 is, that is the FIR, my lord. The FIR is, my lord, much as my lord, 6 months delay, my lord. As because, my lord, it from the FIR itself, it reveals that, my lord, the FIR has been lost after 6 months, my lord. And my lord, the complainant in this case, my lord, is the married lady, my lord, and she has, my lord, one college going son also, my lord.
Heard Mr.
Lord, may I please, Lordship? Lordship, here in this case, Lordship, 6 months earlier may be incident, Lordship, but Lordship, thereafter she is being blackmailed. She was being constantly blackmailed.
Heard Mr. S. Ahmed, the learned counsel appearing for the accused applicant, also heard Mr. P.S. Lakkad and an APP for the same. This is an application under so and so. An FIR was lodged on 9/3/2026 by the informant alleging that the accused applicant who runs a stationery shop in front of her house, came to her house, came to her house 6 months ago. And while she was taking her bath, he took certain photographs of her. He took certain photographs of hers while she was taking bath. And the incident happened 6 months ago. And after the incident, the accused applicant started blackmailing the informant and created a physical relationship with, created a forceful physical relationship with her by such blackmailing. On receipt of the FIR, the police registered Kolgachia PS case number 24/2026. Full stop. Call for the CD. Let the matter be fixed on
On 25th,
23rd of April. 23rd of April.
20
No entry. Let it come.
It's
Lordship, this is the anticipatory bail application and the alleged sections comes under the NDPS Act.
Hmm?
The alleged sections comes under the NDPS Act, Lordship. Here in page 8, annexure A, where the complaint petition is there, here one accused named Naren Datta. From his possession, 321 grams of heroin was found. But my petitioner name, that is Lipibrot Nath, his name is not mentioned in the FIR. But a notice was served against him from the NCB. So Lordship, kindly CD may call regarding this matter and interim may consider because his name is not in the FIR, in the complaint petition, Lordship.
Where is the complaint petition?
Lordship, page A8, annexure A.
Oh. Extra copy is given. Where?
What was the quantity seized?
Lordship, 321 grams of heroin was,
321 grams.
yes, Lordship.
Where is it mentioned?
Lordship, it is mentioned in, Lordship mentioned in page 8, annexure A, Lordship.
Is at page 8. Where?
Lordship.
Page 8 where?
Uh,
I can't see.
The second line, Lordship.
Hmm?
Second
Yes,
line.
second line, yes.
Second line.
321 gram of heroin, yes. And where is the notice?
Lordship, it is in annexure B, page 11.
So this is only an intimation to, find out certain facts. Why are we apprehending arrest?
His Lordship, the notice was served. Names my name from the NCB.
No, your name is not there. You have been only asked to appear before the investigating authority. And you need to cooperate it. I mean, section 67 doesn't give power to the investigating authority to arrest him. Does it give any power? It doesn't give any power. Mr. Chaudhary? I mean, only thing is that he is apprehending because, but there is no power, but since.
There's another aspect, but Lordship, if your Lordship has noticed, annexure B, that was issued on 19/2. She was asked to appear on 6th March.
6th March. Yes.
6th March. Now,
The date is
had
gone.
it
Whether you
been
have
a
written to them.
case- Had it been a case where she would have come before this court prior to that.
This
things would
update
have
is
been-
already gone.
But now, Lordship, the suspicion is there.
And whether you have written any intimation to them that you could not appear or you won't be able to appear on 6 months, so that should be extended or you should be given a different date.
Lordship, regarding this, I
Huh?
have no instructions. I have to take instructions, but Lordship.
See, madam, while filing these kind of applications, you should have all this full information. Otherwise, how will you, protect your client and file a case? You are filing a case, but you are not, you don't have the instructions. At least this document you have seen, you have annexed. You should have reasonably questioned your client that what has happened, 6 months date is already over. Why have you appeared or why didn't you appear? Did you ask those questions to your client? The 6th is already over. And you are not able to answer also whether you have written any letter to, you have sent any communications to him, to the authority, asking for a extension of date or whatever. What is to be done?
Perhaps not at this stage.
Eh?
Perhaps not at this stage. Let the bail petition be pending, Lordship. In the meantime, Lordship may call for the CD, but interim, I do not think, Lordship, this is. We will see what is there, Lordship, if there are materials. Because it would have been bona fide had she approached before, or as it has fallen from your Lordship, has there been any
But
communication?
67 notice only says, about,
Call for information.
that's all.
He has to cooperate, Lordship.
Let him appear. on a different date, you put a different date. Or will pass an order saying that he will appear on this date, because I think,
After this, maybe some other notice has also been issued. I do not know,
Hmm.
because this is quite old. I leave it to your lordship, if your lordship fixes a date.
we'll fix a date and let him go and appear. I mean,
Lordship,
she has missed out in certain information. But she's a young, she's a young
Lordship.
counsel. So we'll consider this. I'll just come back in 5 minutes. Your name?
Lordship M. Bhuya. M. Bhuya, Lordship.
Heard MS M. Bhuya, the learned counsel appearing for the accused applicant. Also heard Mr. R.K. Dev Chaudhary, the learned DGSI appearing for NCB. This is an application under section 482 of BNSS, 2023, praying for pre-arrest bail. Pre-arrest bail for the accused applicant in connection with NCB Gauhati crime number 2/2026 under section 8 in bracket C /21 bracket C of NDPS Act 1985. The case of the petitioner is the case of the accused applicant is that on 27/1/2026, the officials of narcotics and officials of NCB, Gauhati General Unit allegedly seized 321 grams of heroin from the conscious possession of one person, namely Naren Datta. Naren Datta, resident of Heusi Nagar, Guwahati, Beltala, Kamrup Metro, Assam. During a search and seizure operation conducted by the NCB officials. Next para, on the basis of the said recovery, NCB Guwahati crime number 02/2026 was registered in the aforementioned sections. Full stop. The learned counsel appearing for the accused applicant submits that that accused applicant is no way connected to the alleged offense committed by the aforesaid Naren Datta. However, a notice under section 67C of NDPS Act has been issued. Notice under section 67C of NDPS Act dated 19/2/2026 was issued to the accused applicant, requesting him to appear before the NCB officials. Concerned NCB official on 6th March 2026 at 10 p.m. at 10 a.m. positively. Full stop. On due to the receipt of the aforesaid notice, the accused applicant is apprehensive of his arrest and therefore filed the instant pre-arrest bail application in the instant case. The learned counsel submits that he will cooperate with the investigation, and appear before the investigating authority on a date that may be fixed by this court. Stop. Mr. R.K. Dev Chaudhary, the learned DGSI, submits that the date of appearance is already over and he doesn't have any instruction as to any extension of any extended date has been given to the accused applicant for his appearance. Full stop. Next para, taking into account the aforesaid facts, this court is of the considered opinion that the accused applicant can be given the privilege of pre-arrest bail by a direction to appear before the NCB officials on a particular on a particular date, full stop. In view of the aforesaid, it is directed that in the event of arrest of the accused applicant, the accused applicant shall be released on furnishing of a bail bond of rupees 30,000 with a security of like nature to the satisfaction of the NCB. To the satisfaction of the NCB.
Yes, Lord.
To the satisfaction of the NCB of persons, subject to the following conditions also. That the accused applicant shall appear. Should we give a particular date?
It would be better, Lordship.
Shall appear before the NCB officials on, when can you appear?
Lordship, at any convenient date, I know.
17th.
Huh?
17th.
17th. Okay, appear before the NCB officials on 17th, 17/4/2026 at 10 AM. Positively, full stop. Next, next you write that the accused applicant shall cooperate with the investigation and provide all the materials that may be sought for by the NCB officers also. In terms of the aforesaid direction, the instant AB application is disposed of at the motion stage itself.
27. My lord, the FIR, your lordship comes to, my lord,
Why officer in charge is also made a party? Then we'll have to give a notice to the officer in charge.
that may be deleted, my lord.
How can it be deleted now? You'll have to file APFS.
Notice, my lord, in fact, public prosecutor will.
Lordship, if someone is being a made party, so we cannot, Lordship.
Why do you do this kind of mistakes? I mean, that is not required at all.
Nothing. This, my lord, not by name, my learned friend, can I represent him, my lord.
Mr. Locker, what is to be done? Can you take notice on this? No, what is the case?
My lord, in fact, the FIR at page 12, my lord, it mentions two accused persons, my lord. One, Mohammed Shakir and Rasdeep. And petitioner is neither of them. And the allegation is, my lord, that they entered into agreement with the informant, my lord, accepted money for higher returns, my lord. This allegation is against them. By this time, my lord, they have been granted bail. And along with that, my lord, FIR at page 14, your lordship will see, my lord, there are certain other persons, my lord, who are named, total 13%. But, my lord, no specific, my lord, allegations are attributed to them, my lord, in the FIR. And the present petitioner, my lord, he is at serial number 6, my lord, Jahed Ahmed Shimu. And this honorable court, in respect of some other, my lord, co-accused in this particular list, my lord, have, my lord, allowed them to go on bail to, my lord, give the statement before the IO, my lord, interim protection has been given, so that they can cope with the investigation and give the statement. And, my lord, my respective submission is, my lord, the present petitioner is not at all involved.
Where are those orders?
Yes, my lord. I don't want to put. These, my lord, persons, they figure at serial number 3, Jahangir, my lord, serial number 13, Oliullah, serial number given, and serial number 11. 3, 11, and 13, my lord. They are at serial number. They, everybody has been granted after interim, they have been granted, my lord, absolute bail also, man, after cooperating with the investigation, man. They get a final bail, get a negi. Interim also.
কিমান নম্বৰ? জাহেদ আহমেদ। আপোনাৰ কিমান নম্বৰ? জাহেদ আহমেদ।
মোৰ প্ৰেজেন্ট পিটিশনাৰটো ন?
হা?
প্ৰেজেন্ট পিটিশনাৰটো তোমাৰ নাম্বাৰ হৈছে হেৰি
Mr. Locker, I think we can dispose it of.
Because Lordship, probably what is his apprehension that is not also clear, Lordship, because
No, their name is there in the FIR and the coordinate bench has already given them bail, bails have been made absolute. Then
in
what-
the affair, he's not name accused, Lordship.
Huh?
He's not name accused, Lordship.
No, his name is there in the.
Then
this-
that is the seizure list, that the documents were seized.
No,
from
correct,
the-
correct, correct. Similarly placed people have been already granted bail.
That can
They are appearing before the court.
others,
And if they do not appear, then a different thing.
Lordship.
The Caesar list, their names were there. So that's why they are apprehending. I mean, already,
Probably all these persons took money from that person, Lordship.
No, no, it
He
is
is
not in
then-
the, no, my learned friend, should place the facts correctly. My lord, it is part of the FIR.
the part of the affair, yes, yes,
Part of
yes.
the FIR,
That's what.
the list.
Part of the affair, Mr. Locker. It is there at page 14.
Yes, my, and
Page 14 is Jahid Ahmed is serial number 6.
this is type copy of page 15. If my learned friend comes to page 15, my lord, your lordship will see down below, received and registered so and so. It is part of the FIR, my lord.
It's part of the affair.
Yes,
part of
madam.
the- Heard Mr. S.K. Talukdar, the learned counsel, appearing for the accused applicant. Also heard Mr. P.S. Locker, the learned APP for the state. This is an application under section 482 of the BNSS 2023, praying for granting pre-arrest bail to the accused applicant in connection with Badarpur PS case number 48/2025 under section 61 in bracket 2, comma 318 in bracket 4, comma 316 in bracket 2, comma 316 bracket 5 of BNS 2023 read with section 21(1), comma 21(2), comma 21(3) of banning of unregulated deposit schemes act 2019. The gist of the case is that on 14/3/2025, one Mohammed Tahiruddin Tahiruddin, comma, Kartik Chandra Day and Bilal Ahmed lodged an FIR before the officer in charge, comma, Badarpur Police Station, Sribhumi, alleging inter alia that two persons, namely Mohammed Sakir and Rajdeep Dev, introduced themselves. Introduce
May I
them-
submit one thing, Lordship? Lordship, instead of making it absolute, Lordship may kindly call for a CD.
No, no,
because,
no,
sir,
no, no, no.
I
I
have-
mean, it has already been made absolute. I mean, there is no point keeping certain things unnecessary.
Earlier, after going through it is made absolute, Lordship. I'm going.
So, will there be anything, I mean, a coordinate bench has already, after going through the CD, has given interim. After that, that has been made absolute, after considering the submissions. Now, the similarly placed persons have come before this court. I mean, whether I can take a different view.
And this is at least CD.
No, whether I can take a different view.
Go and appear
No,
before. the
Mr.
High Court.
Locker, see, if you submit something which is really palatable to this court, this court is agreeable. But after considering the CD, interim was granted, similarly placed person, similarly named FIR person, and they have been granted interim bail. After that, they have been appearing, and after that, that has been made absolute. The now keeping for the, I mean, this thing pending and calling for the CD, what more will come from there? Nothing will come. If something is, I mean, something comes out, I mean, like if you say that like, okay, no, this material may come out. If you say something, then I can consider it. But there is nothing like that. What was the last line? Themselves as stock market traders and make stock market traders and by making representations of high returns induced the informants and other unemployed youths of the area to invest money with them. Full stop. It was also alleged that initially some returns were paid, but later on the accused persons stopped making payments and allegedly misappropriated the invested amounts. Full stop. On receipt of the FIR, the police registered the Badarpur PS case number 48/2025. The learned counsel appearing for the accused applicant submits that the accused applicant's name has also been included in a list appended to the FIR alleged to have been involved alleged to have been involved in the aforesaid scheme, alleged to have been involved in the alleged scam as narrated in the FIR. Full stop. Full stop. The learned counsel appearing for the accused applicant submits that though his name was though the name of the accused applicant has been mentioned in the list, however, no specific charge has been alleged against the accused applicant. Full stop. He further submits that similarly placed persons who were also named in the list appended to the FIR have already been granted bail by the Gauhati High Court. And therefore, he submits that that accused applicant should be also granted the privilege of pre-arrest bail. Full stop. In terms of his submission, the learned counsel has submitted the orders passed in the aforesaid bail applications by coordinate bench of this court. Full stop. Mr. P.S. Locker, the learned APP, on the other hand, submits that case diary should be called for, and at this stage, the pre-arrest bail should not be granted to the accused applicants, as something may transpire in the case diary. Full stop. This court has considered the submissions made by the counsel appearing for the respective parties and taking into account of the fact that similarly placed persons have already been granted the privilege of pre-arrest bail by coordinate bench of this court is of the considered opinion that the privilege of pre-arrest bail should be also granted to the accused, also granted to the accused applicant in the instant case. Full stop. Accordingly, it is directed that in the event of arrest of the accused applicant in connection with Badarpur Police Station, case number 48/2025, the accused applicant shall be released on furnishing of a bail bond of rupees 50,000 with a surety of like amount to the satisfaction of the arresting authority, subject to the following conditions. Number one, the accused applicant shall appear before the investigating officer within a period of 10 days of passing of this order. Second, you write that the accused applicant shall cooperate with the investigation and shall make himself available before the investigating officer as and when required. Number three, you write the accused applicant shall not try to influence or induce any witnesses that may be connected with the instant case, full stop. In terms of the aforesaid direction, the instant AB application is disposed of as allowed.
I'm deeply aware. But item 33 also relatable to same FIR, madam. He is accused number 9 therein. 33. Go ahead, madam. Page 15, serial number 9, madam.
The list is not there.
Page 15, madam.
Yes. Serial number?
Serial number 9, madam. Abu Tahir.
9.
Nine.
Okay, same order will go, the name will be changed, okay. Same order will. Item number 33.
I'm deeply aware.
28.
Four 82 application, FI is at phase 10. There is a delay of 24 days, Lordship. The main incident is, Lordship, that the complainant's husband is a thief, Lordship. He went to commit theft at the house of the accused petitioners, Lordship.
Accused petitioners.
Yes, Lordship. When you was caught, Lordship, and Lordship, all are from the same family in the FIR. Only one person, that is accused number 6, he is the neighbor, Lordship. After this, this FIR was lodged, Lordship.
Who are the accused person? Accused, let's see the FIR page 10.
Yes, FIR.
With this, these are the complainants, right? Jabbar Ali and all.
Husband, Lordship, is a thief, Lordship.
Complainant's husband,
Yes, Lordship.
complainant is Rasida Begum.
Yes, Lordship.
Her husband is a thief.
Yes, Lordship. All this, Lordship, false story, Lordship.
No, in the FIR, what has been alleged? With due respect, I would like to inform you that 1 month ago, accused number 1. Who is accused number 1? I think.
All the petitioners are from the same family, Lordship. There's another accused also. He's the neighbor, Lordship.
Madam, there is some problem with the translation.
Lordship,
There is some problem with the translation.
in the translation. The translation.
See, you are writing name of the, in the translated page, you see page 10, name of the complainant, Jabbar Ali, so and so, all residents of so and so. They are the accused persons. How can they be complainants?
These are the.
Oh, yes, Lord. Oh, that was mistake. Rasida Begum, Lordship. That I missed. But Lordship.
No, I
page
mean, see,
11
this,
page 11
this is a printed FIR, correct? Only thing is that you'll have to type it out,
Yes, Lordship.
correct? And there is a mistake there.
Yes, Lordship. Name of the complaint, Lordship.
So when you read this FIR in your typed version, then with due respect, I would like to inform you
Then I
that
do the
1 month
correction,
ago,
Lordship.
accused number 1. Then who is the accused number 1? How
Yes,
do I
Lordship.
find out?
Accused number 1 is actually Jubair Ali, Lordship.
So how
And
do
the
I
page-
find out? How do I find out? You have written name of the complainant. There are some serious allegations against you.
It's a false Lordship, allegation, Lordship.
That
But
will
at least
find,
before
that will.
They can franchise their vote, Lordship, at least interim protection.
No, no.
Lordship, that after CD is received with any allegation, the bail may be rejected, Lordship.
Casting of vote,
Yes,
that
they
may not
pay
be a
for
ground for
it,
seeking
Lordship.
bail, Lordship. That he's going to cast his
No,
vote.
Lordship,
That is in for that he is being go on
it's a
bail.
fact that Lordship, the complainant husband went to.
And even that person has been
Lordship,
rescued by the neighbor as per the Azhar Lordship.
Serious allegations, madam.
no
We'll have
such
to,
there's no such injury also, Lordship. As per my instruction, Lordship.
There was?
As per my instruction from a client, there's no such injury also.
There was?
To the, this victim, the thief, Lordship.
Huh?
Uh,
He,
No such injury was.
no such injuries.
Injury, Lordship.
But that may be your instructions, but we'll go by the FIR.
Because the Lordship accused, they also went to give an FIR. It was not lost by the police.
But, we won't be able to
Register.
give you, madam, we won't be able to give you interim at this stage. The allegations are serious. But allegations are, allegations would have been fine till the time injury is there. But they tried to bury him. That is the allegation. That's a person who is injured and alive and they tried to bury him. That's a serious allegation.
Lordship, if there is any such.
No, so that's why, we'll have to see the case diary and we cannot give you interim at this stage.
It's at least interim protection.
No,
Lordship.
no
Not
interim, no.
On
No, no
21st.
interpretation. Heard MSB Gogoi, the learned counsel, appearing for the accused applicant, also heard Mr. P.S. Locker, the APP for the state. This is an application under section 482 of BNSS 2023. Praying for granting of pre-arrest bail to the accused applicants in connection with Abhayapuri Police Station case number 47/2026, registered under sections 189 in bracket 2/61 bracket 2 stroke 117 bracket 2 stroke 109 of BNS. The gist of the case is that the informant has lodged an FIR or FIR alleging that on 4/3/2026 filed an FIR on 4/4/3/2026 alleging that the accused applicants seriously injured the husband of the informant on 8/2/2026 and thereafter they tried to bury the body of the husband of the informant and informant however the husband was rescued by the local people. Full stop. Call for the case diary. Let the matter be fixed on
On 21st or 22nd?
22nd, madam. 22nd.
29.
Me please, my lord, kindly see the FIR matters page 12, my lord. Petitioner name is not mentioned in FIR, my lord. He is the businessman of Malda, my lord, and his father was at the present. Kindly see the, my lord, page 12, my lord. The
Page
first
12.
page
Yes,
FIR, my lord, copy of 10.
FIR was lodged on 29/3/2026.
Yes, my lord.
Yes,
Accused my lord Rafiq Ali, Manik Ali, Rafiqul Islam, my lord, with your respect, I beg to state that on 27/2026 at about 4 p.m. my loaded 500 bags of maize total weight 24 ton 810 kg on LPG truck bearing registration number so and so at Masgumi Sariali and sent to through the driver Sri Hanuman Trading Company Kamakya Sipazar for sale. At about 7 p.m., the driver told me that the vehicle was at Satpokoli, Tezpur, and at about 10 p.m., he started the vehicle had reached Amingdao. However, at around 11 p.m., the driver mobile phone was found switch off. On suspicion, I contact Buddha Ali, who had arranged the vehicle. The vehicle owner, it was later learned that the loaded truck of corn was located near Sonapur Cement Factory at Supersari Food Private Limited, where the maize had already been unloaded. The matter revealed suspected misappropriation thief of the loaded maize. I informed the police, and accordingly, Sonapur police staff arrested the accused person and pre-admitted. That is the allegation, my lord. And the present petitioner is the businessman of maize, my lord. And accordingly, on that day, my lord, the accused person asked him to purchase the same, but he is avoid to purchase the same because his father was admitted, my lord, Apollo Hospital. Kindly annexer, my lord, annexer to my lord, father medical documents, page 17, my lord. He is admitted 17 years old, my lord, his father admitted in Apollo Hospital, page 18, my lord, dated 33/28. It is the cardiology report, my lord. And till now, he is Apollo Hospital admitted, my lord.
but incident happened on 27th.
27, my lord. And as such, he is that period he is under medical treatment, my lord. And as such, he stated that he is not able to purchase the same. Accordingly, the accused person told him, you have stated any other person who purchased the same. That means, my lord, I told him that one company is there, Sonapur. If you are contact them, then
From where you are saying all these things?
he is the another businessman, my lord, corn. I am the businessman of corn, and the factory I have many times I have supplied a factory, and as such, when the sales point asks me, you purchase the same. I am stated that I am not able to purchase the 500 corn, my lord. Because my father is admitted at medical condition, I treatment my father, and as accordingly they approach me, you arrange the another purchaser because I am not any other person. I am not sell that. And
Lordship,
his name is,
This is partial admission, Lordship, that one person has approached him that for purchasing of that articles, that much is sufficient.
my lord,
His involvement is there, Lordship.
my allegation is that my name is not mentioned in FIR. Police might visit my resident man only for the
Huge quantity
for-
of material, Lordship.
well, because I am not involved in this case. I am the reputed businessman, my lord. The sales boys asked me to purchase the sales. I stated that I am not able to at that.
Okay, let's
period, I am not
interim, let go, because he's not named in
Materials are
the.
not
My
yet been
name is not
recovered,
mentioned.
materials are not yet been recovered, huge quantity.
My position, my lord, I am not present.
Yeah,
at
yeah,
that.
yeah, I have heard your submission, let him.
Huge quantity of material, Lordship, that may not be recovered after if he is getting allowed to
Already
go on
recovered,
interim
my lord.
protection, Lordship.
Already recovered. All the recovered from the position or other accused person, my lord.
What likely?
So recovered. Azhar sufficient. Azhar stated that. Now all the thing I informed that, and accordingly Sonapur police is arrested. All the thing are recovered, my lord.
And from where you're saying so?
Sonapur factory, my lord. All that period, corners unloaded, my lord. And that period, my lord, police visit the place of occurrence, and all the articles are already recovered, my lord.
Where it is, Lordship? Before the submit.
হ্যাঁ, আছে দেখুন, ওখানে আছে।
আপনি ইংরেজি মাতাছেন?
Oh.
লিখছেন আপনি?
That is, all the things are recovered,
It has been unloaded, yeah.
unloaded, my
That
lord.
FIR you see, page 10,
Where is them?
mm,
Keep of the loaded,
where the maize had already been unloaded.
already been unloaded, my lord.
The matter reveals that
I
the
informed-
doors have been recovered.
Already recovered, my lord.
Only thing is that, I mean, there is a suspicion that he may be a purchaser.
He is a purchaser, he told the other person.
If you say that like he is the purchaser, regular purchaser, then I will not give you bail.
My lord, I am, at period, my lord, I am not in.
Now, are you admitting that like you are a regular purchaser of theft?
No, my lord,
huh?
no. I am purchased the corn, not the theft corn, my lord. I have purchased the corn some other person, not for on that accused person, my lord. I have purchased, my shop is there, my lord, corn shop. And as such, I purchased the corn in various person, my lord, not for the single person of the accused person, my lord, not the thief article, my lord. I purchased the on and reputed shop, my lord, my established, my lord.
Okay, Mr. Locker. Let her go, I mean, interim.
Interim protection may be given, my
As
lord.
materials are recovered, Lordship.
Let him go. I mean, he is not named also. I mean, only allegation is that like he was.
On interim, Lordship, CD may be called for.
Will it be required?
No, it will be required. It may be required, Lordship, because Lordship, his involvement we have, Lordship, may see, Lordship, because.
Okay, I heard Ms. MS.
R.
R.
Kolita.
Kolita, the learned counsel, appearing for the accused applicant. Also heard Mr. P.S. Locker, the learned APP for the state. This is an application under section 482 of BNSS 2023, praying for pre-arrest bail of the accused applicant in connection with Choigaon police station case number 62/2026 under section 61 in bracket 2/3033 bracket 2 of BNS 2023. And next paragraph, an FIR was lodged by one Jaharul Ali on 29/3/2026 before the officer in charge Choigaon police station alleging that on 27/3/2026 at about 4 on 27/3/2026 the maize belong to Jaharul Ali.
Yes, ma'am.
The maize belong to the informant, loaded contained in 500 bags, was loaded on a LP truck bearing registration number AS01 KC-3133 at Mazgumi Chariali. Mazgumi Chariali and sent it through the driver of Hanuman Trading Company, Kamaikha, Sikajar for sale. It was alleged that the informant found the driver's mobile phone switched off, and on suspicion, when the informant contacted one person, namely Guda Ali, it was learned that the loaded truck of maize was located at Sonapur Cement Factory, near Sonapur Cement Factory at Super Sri Food Private Limited, where the maize had already been unloaded. Full stop. It was contended, it was alleged that since the loaded truck was found in a different place rather than in a place of destination, it was suspected that the aforesaid maize loaded truck was taken to that place for selling the same illegally to different persons. Full stop. On receipt of the FIR, the police registered the Choigaon police station case number Choigaon police station case number 62/2026. Full stop. So how your name has come up?
My name, my police, visit my resident.
Okay, then you write. The learned counsel appearing for the petitioner, accused applicant submits that the accused applicant is a purchaser is a regular purchaser of maize, and he is into the business of selling and purchasing and selling of maize, and therefore the police visited his shop inquiring about any proposed purchase of such maize. Full stop. Being apprehensive of his arrest due to the visits of the police, the accused applicant has filed the instant pre-arrest bail application. Full stop. The learned counsel submits that since he is no way involved in purchasing of any theft material, any theft measure, full stop, he should be allowed to go on bail. Full stop. If she further submits that in fact the accused applicant was busy with his father in
Apollo Hospital.
Gauhati.
But
Was busy in Apollo, was busy with his father, who was admitted to Apollo Hospital, Gauhati, at that point of time. Full stop. The learned counsel, the next pair, the learned APP for the state submits the CD in the incident case should be called for, and he opposes the bail application, pre-arrest bail application at this stage, taking into account the whole aspect of the matter and
interim protection.
and the fact that the loaded maize, that 500 bags of maize has already been recovered. This court is of the considered opinion that at this stage, interim protection to the accused applicant can be granted. Accordingly, it is directed that in the event of arrest of the accused applicant by the investigating authority in connection with Choigaon Police Station case number 62/2026, he shall be released on bail on furnishing of bail bond of rupees 30,000 or rupees 50,000 with a security of like nature to the satisfaction of the arresting authority. Arresting authority. Full stop. Full stop. In arresting authority, then you write subject to the following conditions. subject to following right, that the accused applicant shall appear before the investigating officer uh, within a period of 10 days of passing of this order. Then the accused applicant shall cooperate with the investigation, full stop. Let the matter be listed, call for the CD. Let the matter be listed on
7th of May, Lordship.
on 7th of May. On 7th May.
I love you.
Hmm.
Item 30, first one.
No, please, Your Honor, this application is under 482 of BNSS. Your Honor, FIR is at page 12 to 16, and the type one is from 15 and 16.
Yes.
I was serving as the waiter, your lordship.
Hmm?
Your lordship, the FIR is at page 50.
Yes, I have seen that.
The allegations are not true, your lordship.
Huh?
The allegations that's been leveled against me are not true, your lordship.
Not?
Are not true, your lordship. I was serving as the waiter. And there
What
was,
may be the reason?
I have stated in my paragraph, your lordship, may kindly peruse the paragraph at paragraph page 4, your lordship. P2. I've stated clearly, your lordship. May I read, your lordship?
Yes.
The accused petitioner stated on 4/1/2026, the informant and his friend, the division of Sanoka Resort, and had stayed there in their tents with the facility of staying in tents for overnight is available in Sanoka Resort. The informant and his friends who were staying in the tents were enjoying a party in the night and had consumed excessive alcohol. The informant and his friends had misbehaved with the accused petitioner who was serving food items to them. Moreover, the informant and his friends had mishandled and assaulted the accused petitioner as there was a delay in serving food items, more particularly fried chicken to them. The management and the other staff of Sanoka Resort had somehow rescued the accused petitioner from the assault of the informant and his friends and had tried to pacify the situation. The informant and his friends came to the Sanoka Resort in the morning. It is on 5/1/2026. It is needless to mention here that the informant had lost the present case with an ulterior motive. And the accused petitioner says that the accused petitioner is a victim of certainly not involved with the alleged incident of using criminal force to the girls women with the intent to oppress their modesty. I'm a waiter, your lordship, in this particular.
You're a waiter.
Waiter. And the fact is that on that particular day, the incident happened, your lordship. Later on, they had filed a case, your lordship. In fact, if your lordship may kindly peruse the FIR, your lordship will see that they have stated that we left by lodging a complaint in the results. They have stated in their FIR, your lordship, that they had left by lodging a complaint in the result. So they were afraid that we might file a case against them for creating the brawl in that particular night. And that is why they have filed this case, your lordship. Unfortunately, no case was filed by the management. And now I am a victim, your lordship. So considering this aspect, your lordship, may I pray some protection will be granted to me, your lordship, in this case.
Section is 74, ma'am. Assault or use of criminal force with intent to outreach modest. That is the section.
Okay, but let him go. We'll dispose this of. We'll dispose this of.
Or my lord, interim may be granted, my lord. He will go and appear, my lord.
What is there?
Because of, only because of the section, my lord, I'm submitting. Otherwise not, my lord.
Right, heard Mr. T. Deori, the learned counsel, appearing for the accused applicant. Also heard Mr. K. Buster, the learned APB for the state. This is an application in writing. This is an application, so and so. The gist of the case is that on 5/1/2026, the informant Bikramjit Muzumdar had lodged an FIR stating entirely that on 4/1/2026, about 2 o'clock during the day, the informant Sri Dhiren Nath, Srimati Kajal Thakuria and Srimati Bonti Thakuria went to Chanaka Resort for picnic, and they decided to stay there for the night. Full stop. It was further alleged that the accused petitioner had made all the arrangement of the stay in the said resort. It was also alleged that when the lights of the tents were switched off, the informant and their friends had gone to sleep inside the tents. The accused applicant, by taking advantage of the fact the informant and their friends were asleep, came inside both the tents by unzipping the chains of the tents and had touched the chest of both the girls. On receipt of the FIR, the police registered Mayong Police Station case number 505/2026 under section 74 of the BNS 2023. Go now. I mean, I don't think, there is anything. When you write, the learned counsel appearing for the accused applicant submits that the informant and his friends had visited the aforesaid resort and stayed in their tents, as the facility of staying in the tents overnight is available in the Chanaka resort. It is stated that the informant and his friends were enjoying a party and consumed excessive alcohol. It is stated that the informant and his friends misbehaved with the accused petitioner, who was serving food items to them. It is also stated that the informant and his friends manhandled and assaulted the accused applicant, as there was some delay in serving the food. It was stated that the management and other staff of the aforesaid resort had somehow rescued the accused petitioner from the assault of the informant and his friends and had tried to pacify the situation. In the morning, the informants have left the place Where's the place? The learned counsel also submits that the instant FIR has been filed falsely, as they feared that the management of the Chanaka management of the aforesaid resort may file an FIR against the accused applicants, against the informants. Full stop. The learned counsel submits that no such incident of any outpacing modesty or physical assault had happened on the particular night. Full stop. In view of the aforesaid, he submits that the accused applicant who is a employee in the resort will cooperate with the investigation, will fully cooperate with the investigation. Full stop. Therefore, he submits that the accused applicant should be allowed to go on previous bail. Full stop. Mr. K. Parasad, Mr. K. Bushra, the learned counsel appearing learned APP for the state, submits that case diary in the instant case may be required for considering the instant bail application. Full stop. Taking into account the whole aspects of the matter and whole aspects of the matter, this court is of the considered opinion that the privilege of pre-arrest bail should be granted to the accused applicant. Therefore, it is directed that in the event of arrest of the accused applicant, he shall be released on furnishing of a bail bond of rupees 20,000 with a security of like nature to the satisfaction of the investigating officer in connection with Mayam Police Station case number 5/2026 with the following conditions. Subject to the following conditions: one, you write that the accused applicant shall appear before the investigating officer within a period of 10 days of passing of this order. And number two, the accused applicant shall make himself available whenever the investigating officer calls for, you write something like this. The accused applicant shall make himself available before the investigating officer as and when called for. Then the accused applicant shall not try to influence or induce any witness that may be connected connected with the alleged offense. Full stop. In terms of the aforesaid direction, the instant AB application is disposed of.
Very good. 31.
Yes, Mr. Ali.
May I please the lordship?
Yes.
But the FIR, my lord, is at phase, my lord, 9, my lord. FIR filed on 22nd of March. On the basis of this FIR, my lord, on the basis of CCTV footage, my lord, one person identified and he was arrested, my lord, phase 15. And on the basis of his statement, my lord, other two accused, my lord, who were accompanied him, they were also arrested. And as per forwarding report, my lord, the 3 persons, my lord, arrested, they were involved. And stolen articles also, my lord, recovered, my lord. Now he named, my lord, the petitioner that one of the, my lord, the ring was, coin was sold to the petitioner. Which the petition is denied, my lord, because the petition is a daily wage labor, my lord.
It is a daily wage laborer.
Lordship. Lordship, kindly see page 15, ground number 2. And on the basis of this, my lord statement, police visited my house.
But that ring was recovered from him, from you.
Lordship, no, it was recovered from the accused number 1.
Accused number 1.
Lordship.
Then, I mean, how it is stated that like, that was stolen to you if the ring is recovered from him?
Lordship. He made, my lord, during my lord police custody, he made statement, my lord. But
No, if,
subsequently,
if it is stolen to you, then how it is recovered from, I'm sorry, if it is sold to you,
Lord.
how it was recovered from the other person?
well, he made some false statement, man.
No, yeah,
One ring was recovered from one Mustafizur who was also arrested. This 21, my lord.
it was recovered from one Noor Alam,
He is the main accused. All
led
material,
and sold by Noor Alam from the house of Mustafizur Rahman. And you are
Arif,
Ariful Islam.
Ariful Islam. As per my lord, the statement, these 3 persons were involved, all 3 persons were arrested. I'll cooperate, my lord.
Yes, Mr. Boyso?
Case of a theft, my lord.
Hmm?
My lord, that is the case of a theft, my lord.
Hmm.
And my lord, where my lord, that is the, my lord, who my lord taken his name from the forwarding report,
But
my
it
lord.
was, but they're saying that it is stolen, but like, it is stolen
My lord.
and sold to somebody.
And
Yes,
section
ma'am.
317 has not been added, my lord.
Hmm?
Section 317 has not been added. And these 2 sections are not applicable in case of petitioner also. As per forwarding report.
My lord, perusal of CD is needed, my lord, because my lord, it is regarding the forwarding report of the other co-accused, my lord.
Okay, we'll give him some interim protection
Fine.
and we'll call for the CD.
My-
Heard Mr. R. Ali, the learned counsel appearing for the accused applicant, also heard Mr. K. Boyster, the learned APE for the state. This is an application under so and so. When we write the case, an FIR was lodged on 22/3/2026, 26, alleging that that when the informant and his family was out of his house for to celebrate Eid, and after the celebration, when they came back to their house, they found the lock. They found that some miscreants have broken the lock and stolen certain goods along with the CCTV camera. Full stop. On receipt of the FIR, the police registered the the Howley PS case number 31/2026 under the aforementioned sections. Full stop. The learned counsel appearing for the petitioner submits that on the basis of the CCTV footage, the main accused persons have already been arrested, and the stolen goods were also recovered from them. However, on the basis of a statement made by one of the accused, made by the accused, the police is searching for the accused applicant, though the accused applicant is no way linked to the aforesaid incident of theft. Full stop. The learned counsel submits that the accused applicant will fully cooperate with the investigation in the instant case. Full stop. The learned APP, Mr. K. Boyser, submits that case diary in the instant case may be may be perused before considering the bail application first. Before considering the instant bail application first. Taking into account the submissions made by the council appearing for the respective parties and materials brought before this court is in the considered opinion that the accused applicant should be given interim relief by way of protecting relief of interim pre-arrest bail. Full stop. Accordingly, it is directed that in the event of arrest of the accused applicant by the arresting authority in connection with Howley PS case number 31/2026, he shall be released on furnishing of a bail bond of rupees 30,000 with a security of like nature to the satisfaction of the arresting authority, subject to the following conditions. Number one, that he will appear, the accused applicant shall appear before the investigating authority within a period of 10 days of passing of this order. Then accused applicant shall fully cooperate with the investigation and make himself available before the investigating authority as and when required. Full stop. Next para we write call for the CD and let the matter be fixed after the ensuing revocation.
It may be fixed, madam.
30th of April
30th.
or first week of May. First week of May.
First week of May.
We have a lot of matters in fixed.
5th of May, madam.
5th of May.
5th of May.
5th of May.
32. 32, my lord, the FIR, my lord, case 9, my lord.
Page?
Case
FIR?
9, my lord.
Huh?
Case 9.
9.
Got
He died or what?
Caution. Just one day before the marriage, my lord.
Then it will be difficult.
Diary may be called for. Case diary may be called for, my lord, along with report.
Why case there is required?
Just
Why?
postmortem report, my lord. The doctor opinion will be, my lord, revealed, my lord. Based on the day of, just before the day of marriage, my lord. They had love affairs. They fixed the date of marriage. And the petitioner is a teacher. He was, my lord, busy in, my lord, marketing for marriage. And she consumed, my lord, poison. But the FIR was filed in otherwise.
Okay, heard Mr. R. Ali, the learned counsel appearing for the accused applicant, also heard Mr. K. Busher, the learned APE for the state. This is an application under so and so. Then you write, an FIR was lodged on 3/1/2026 before the Howley police station alleging entirely that complainant's daughter was having a love affair with the accused petitioner for the last 2 years. 2 years, semicolon, that The guardians of both the families sit together and fixed a date on 31/12/2024 for their social for their marriage. Full stop. Full stop नहीं समय करो ना that on 30/12/2025 the accused applicant went to the complainant's house to meet the girl when no one was there, and after conspiring to kill the girl, mixed some poisonous substance with ORSL and made her to drink the same. Semicolon, that after drinking the poison, after consuming the poisonous drinks, the daughter of the complainant became unconscious, and the accused fled away from the house of the complainant. Semicolon, that the daughter of the complainant was admitted to Borpeta Hospital in critical condition. Thereafter, she was referred to Gauhati, from where she was discharged, full stop. But the complainant's daughter's health got deteriorated, and but at the time of filing of the affair, she was alive.
She was alive.
Deteriorated. Full stop. It was full stop, semicolon, that the accused applicant conspired. It was alleged that the accused applicant conspired to kill the complainant's daughter in a pre-planned manner. Full stop. On receipt of the FIR, police registered Howley PS GD number Howley PS case number 03/2026 under the aforementioned section. It is submitted that subsequently, next balance is submitted that subsequently the daughter of the informant expired. Full stop. Call for the case diary. Let the matter be fixed. On
Need it after vacation, madam, as you.
on 29th April,
29th.
Diary along with my PM report.
the call for the case diary along with the postmortem report.
Obviously.
May it please your lordship. I may be allowed to withdraw this with a liberty to approach the learned trial court.
Okay, the learned counsel appearing for the accused applicant submits that he should be he may be allowed to withdraw the instant application with a liberty to approach the trial court. Full stop. The instant application is dismissed on withdrawal.
Deeply. May I please, my lord, in this case, my lord, petitioners were granted bail by your lordship, my lord. Page 8, my lord. And 11, my lord, page 11, my lord. They were asked to appear before the alia, my lord, within 10 days, my lord. But the petitioner was totally unaware about this order, my lord. And due to some
Petitioner was unaware. Why?
due to some miscommunication with their counsel, my lord. And your lordship will find, my lord.
No, that kind of pleas will not help.
My lord, kindly see next page, my lord. And since they were not aware, they filed another bail petition, my lord. And this bail petition was detected when it came for hearing, my lord. Your lordship will find page 13, my lord. But it was in the order, it was stated that earlier bail petition was rejected, my lord. It was actually not rejected, it was granted. Page 13, my lord. Due to some communication gap, my lord, petitioner was totally unaware about the earlier order, my lord.
Okay. Lord, Mr.
AHMR.
So-and-so, the learned counsel, appearing for the applicant. Mr. Also heard Mr. K. Boysa, the learned counsel, appearing, learned APP for the state. By an order dated 9/2/2026 in AB number, in AB 180/2026, this court has allowed the accused applicants to go on pre-arrest bail with the condition that the accused applicants shall appear before the investigating officer within 10 days from the passing of the aforesaid order. Full stop. The learned counsel appearing for the accused, appearing for the applicant submits that due to certain miscommunication with the counsel appearing for the accused applicants, the accused applicants were unaware of the passing of the aforesaid order dated 9/2/2026 and therefore unable to appear before the investigating officer within the specified time period. Full stop. The learned counsel submits that submits that the default happened due to non-communication of the aforesaid order by the counsel appearing on behalf of the petition, behalf of the accused applicants to the accused applicants, and therefore an opportunity should be given to the accused applicants to appear before the IO and cooperate with the investigation, and thereafter cooperate with the investigation. Full stop. Full stop. Taking into account the aforesaid submissions and as episode submission, this court is of the considered view that since this court has already granted bail, pre-arrest bail to the accused applicants by its order dated 9/2/2026, the justice will be done if the specified time period is extended by some more days. Full stop. Accordingly, it is directed that the accused applicant shall appear before the investigating officer in connection with Patsala PS case number 3/2026 within a period of 10 days from passing of the instant order. Full stop. It is also directed that the accused applicant shall fully cooperate with the investigating authority and investigating officer and make themselves available before the investigating officer as and when called for. Full stop. In terms of the aforesaid direction, the instant IA is disposed of.
We'll hear you.
My lord, we received a communication, my lord, that is, my lord, this served, my lord, on the respondent number 2, my lord.
Respondent number 2 served.
Yes, my lord. That may be taken as a part of the record, my lord.
Okay. Heard me say?
Yeah,
Huh?
double R Karim.
Your name.
Double R Karim.
I'm not hearing what you're saying.
Double R Karim, your lordship.
Double
AR Karim.
AR Karim. Heard Mr. So-and-so. And also heard Mr. K. Boysa, the learned APP for the state. The learned APP for the state submits that notice upon respondent number 2 has been served. In that regard, he has submitted a communication, namely return after service, which is kept on record. Full stop. So we'll post it after the vacation. If no one appears, then we'll appoint somebody. Okay. Let the matter be listed after the ensuing view vacation. This has already come.
This year receipt.
This year receipt, my lord.
This.
Item 5.
This matter pertains to freezing of bank accounts, my lord. By the previous order, my lord, the bank council was asked to provide.
Who is appearing?
Bank. Yes. Yes, so.
Is anybody appearing for the bank?
Yes, my lord, on other occasion, one.
Now, whether somebody is there, no.
No, today, no. Nobody is there. Minal Parman. Oh.
You have to post it after this thing, because there is no other way. Heard Mr. P.K. Muni, the learned counsel, appearing for the petitioner. Also heard Mr. H. Sharma, the learned additional senior government advocate, appearing for respondent number 1. None appeared for the respondent bank. Please stop. Let the matter be listed after the view vacation.
Can we date maybe fixed, my lord?
Then it will go to May, huh? May. Let the matter be fixed on 13th of May.
Can it be?
Because that's a book.
My difficulty is that my whole account has been.
I understand that,
And
but
the
if you
petitioner
want a fixed date, then it will go to May. Then okay, let it be on 5th of May.
is 5th of, I'm deeply okay.
Let it okay.
Dates.
Matter will be matter, takes after vacation, my
Okay, on the prayer of the learned counsel appearing for the petitioner, let the matter be listed after the ensuing view. Mr.
Art Talukdar,
Art Talukdar is
appearing for the respondents.
Huh?
For the respondents.
appearing, appears for the respondents.
In item 7, Lordship, we have been directed to obtain instructions, but Lordship, we are facing certain difficulties because no steps has been taken by the petitioner. So without there being a extra copies, we are unable to get that instructions.
Okay. You serve extra copies?
I'll submit that.
Heard Mr. M.S. Sheikh, the learned counsel appearing for the petitioner. Also heard Mr. H. Sharma, the learned additional senior government advocate for the respondents.
Lordship.
For the
Like
respondents.
2 and 3.
Respondent number 2 and 3. Mr. Sharma submit and Ms.
Official date.
M.S. P.M. Mohanta for respondent number 1. Then you write, Mr. H. Sharma, the learned counsel submits that that extra copies of the petition has not been, extra copies of the petition have not been served upon the, served upon him to obtain the instructions, full stop. The learned counsel is directed, learned counsel for the petitioner is directed to serve extra copies to the counsel for the respondents to take instructions in the matter. Let the matter be fixed after, in the month of May.
Here I was directed to furnish my pen a copy of this to category of persons
Hmm?
who are evicted, my lord.
Hmm.
But my lord, due to matter, the collector has been transferred from, and that's a
You
difficulty.
need some time.
Need some time to, Lordship will post it after the view vacation, my lord. I'll furnish the copy of that particular list of persons, my lord.
Okay, heard Mr. M.J. Borwa, the learned counsel appearing for the petitioner, appearing for the petitioner. Also heard Mr. S. Bora, the learned counsel appearing for the respondent. Mr. Bora submits that he requires some time, some time to complete his instructions. Accordingly, let the matter be listed after the ensuing view vacation.
One thing, let them come to compliance order because this is a complaint case and 2 years, 1.5 years back directly.
Everything has been compliant, only the list has not been provided.
Oh,
That's the.
Petitioner says that they have not
given this space, my lord. So outsider is still there. So to clarify, list should be handed over to us.
That
So
will,
let them hand it over, but compliance order should be also there, my lord.
everything has been complied with. They are evicted, only the least thing he needs it, my lord.
So let him complete, I mean, the next date will, I mean, if he
Yes,
doesn't, then,
definitely.
because he's saying that somebody, I mean, this concerned person is
My lord.
transferred.
Otherwise, his livelihood is affected for long.
Okay. Okay, I'll just modify a little bit in the order.
That particular
That list will, you will
list
be.
will be
sub-
provided to him. Just
Huh?
directly. List will be provided to him. I was supposed to hand over the list.
So I'll write, okay, then write completed instructions by providing a list of,
List of the
of
category of person which have been evicted and which are placed there. And I will be providing him the list.
My lord, that is the,
list of the persons
list
who
of
have been,
persons who are
already,
unauthorized.
who have been evicted,
Evicted, yes.
evicted due to their unauthorized
Unauthorized.
And in
occupancy.
compliance of the order, my lord.
Occupancy in compliance of the earlier order.
And who are genuine permissive.
No,
they
that
should-
those things, I mean,
everything will be-
if that list comes, then you'll.
Basically, everything will be claimed. Lordship posting on. Lordship physical.
After the vacation,
Lordship.
after the vacation,
One date. will be-
okay. And on 29th of April,
Lordship.
let the matter be listed 29th of April.
Obvious.
Mr. Sharma is also appearing.
11.
Item 11, Lordship, I am praying for some more time to get the instructions.
Okay.
Because of
Heard-
this,
Heard MS, You have
service is also not complete.
service not complete. Okay, await service report, MS
And Sodhuri.
and
And Sodhuri.
Sodhuri is present for the petitioner. Mr. H. Sharma, the learned
2 and
additional-
3.
learned additional senior government is present for respondent number 2 and 3. Mr. Ghosh, AK Ghosh for
For 1, 5, 6 and 7.
1, 5 and 6. Kotaki for respondent number 4 is also present. Let the matter be listed after the, in the first week of May.
Service of notice with the respondent number 5 awaited.
Service report, service report awaited. Let the matter be listed after, let the matter be listed in the month of May.
Date may be fixed, Lordship.
No, May.
Alia.
Lordship, this is an account freezing case. Lordship, the office report says that the AD has not been received. However, the tracking report shows that the items has already been delivered. So Lordship, service will be deemed to be completed.
Heard, Mr.
Ye dekha.
K. Dekha, the learned counsel for the petitioner. Service. Service is complete in the instant case. Let the matter be listed after, let the matter be listed in the month of May for admission in usual course.